you very much. Good morning, everyone, and very warm welcome to you all to ADBI and Tokyo. Thank you very much. And I think many of you arrived in Tokyo yesterday or day before, very few on the day before. Yeah, thank you very much for bringing very nice weather. So by nice weather, I don't mean just very sunny day, but also low temperature, because it's normal to have low temperature in February in Tokyo. So the previous years and the previous weeks, the temperature are too high for me. I'm 60, almost 65 years old. So for me, it's really abnormal. So thank you very much for bringing things back to the normal situation. So you are very good people who make the things normal again. And then this ADB Institute is a subsidiary of ADB, which is located in Manila, the Philippines. And we are the think tank. So although we are subsidiary of the bank, we are not bankers. We are think tankers. And then what we are doing is convening this kind of events to bridge the kind of research or science and policy making. So we are, in a sense, very shallow people, not try to exert a strong influence on the particular policy in particular country, but let people, especially the government people in developing ADBs, developing member countries, know the emerging very important issues which are or policy challenges common to the region. So in that sense, we are kind of a think tank similar to Chatham House. Chatham House is known by almost everyone because of the term Chatham House rule. So even those people who don't know what Chatham House rule is, but they know the name Chatham House. So and then when they invited to the Chatham House event or a book publication project, they are happy to contribute. So we want to be like that. So to invite the high-level researchers and high-level policy makers, and then let them talk each other. So then the people gradually learn what important and emerging challenges and the possible solutions. So we have been doing that kind of thing. And then I've been the Dean of ADB Institute for 5 years. And then as soon as I came here, the pandemic was really the huge issue. And then I completely forgot, I'm sorry that I completely forgot another important issue, the ADR. Yeah, I very recently learned that last meeting about ADR held by ADBI was held in 2019 before the pandemic in Papua New Guinea. So since then, we haven't had this kind of very important event for 5 years. So I'm completely, sorry for that. So my ignorance. But last year, ADBI welcomed the new deputy dean, the Byung-sik Jun, who came from the Ministry of Finance, Korea. And then as soon as he arrived, he began talking about this issue and then reminded me of the importance of this issue. So it's very nice. So thank you very much, Byung-sik, for reminding me this very important topic. And then he began working with Tom Clark, the General Counsel of ADB headquarters. So thank you very much, great collaboration. And thank you very much, Ministry of Justice Japan for the great collaboration. So without them, of course, we couldn't have this event. So thank you very much once again for the gathering today and tomorrow to discuss important issues and deepen our understanding. So I learned that the Office of General Counsel, ADB, haven't had any big event jointly with ADBI before. Right? So this is also a very nice departure toward the better world. So the house rule from me is that because we just renewed the carpet, and then the owner of this building is very nasty. They don't allow us to use any, service providers from outside. They said we have to ask their, related companies to provide even the carpet and of course cleaning. So, and then before changing carpet, I wanted to have this kind of very nice events here. And then we would have lots of discussions, drinking coffee and teas, and very relaxed. But after actually changing the carpet, or something strange happened. So what's called it? Time inconsistency happened. And then I think, oh, no coffee at all. So if you spit any, coffee or tea, so it may develop into a kind of dispute. So it's okay to bring the bottle of water in this room, but please enjoy tea and coffee in another room. So, and I really look forward to the great fruitful discussions over this, these 2 days about this very important issue. Thank you very much and welcome again.
Thank you very much, Mr. Sonobe. Thank you very much for your warm welcoming remark. Next, I'd like to invite Mr. Thomas Clark, General Counsel of ADB, who has made a significant contribution from the beginning of this event. The floor is yours.
Thank you very much for that very kind introduction. Dean Sonobe, as with so many things, you have given us so much leadership and so much enlightenment and so many good ideas. And hearing your very gracious opening remarks, I was struck by, my goodness, there it is again, another great idea. We obviously have to make sure that in any contracts, particularly with that particular landlord and lessor, that we include an alternative dispute resolution clause. And so therefore, if there is any litigation, you have some forum to bring them to, particularly around those nasty coffee stains. Should they become a dispute, which of course they would. So next room, please. Thank you very much. My name is Tom Clark. I am the General Counsel of the Asian Development Bank, and it's my distinct honor and privilege to be here in this room with such a distinguished gathering of senior legal officials from so many of our ADB developing member countries, with so many senior representatives of all of the leadership that has been mentioned and welcome. Of course, I must express my very deepest gratitude to Dean Sonobe, who has just spoken, the Dean of ADB Institute, to Mr. Byung-Sik Jung, the Deputy Dean, who we've had the pleasure to work with so much. And I appreciate your warm words, Dean, but of course, this has been very much a collaborative team effort. And it is actually the first time that our OGC, our Office of General Counsel, our legal department at ADB has been working so closely on a major event like this with ADBI. And I can only say, I truly, from the bottom of my heart, hope that it is the first of many more to come, because really what we need to be doing is, breaking through some of the silos that exist and any of the organizations we work in and bring together people who really have understanding not only of the law, but of economics, of policy. And that's one of the things we hope with our knowledge sharing and our capacity building programs at ADB that we can continue to do. And I'm absolutely delighted and honored by the presence at the main table of Mr. Yoshiki Tsutsumi, who's the Assistant Vice Minister from the Japanese Ministry of Justice. Thank you so much. You honor us with your presence today. And I also believe that we have, through the miracles of technology, Ms. Anna Jubin-Brett, Secretary of UNCITRAL, and Ms. Antita Komodar, Head of UNCITRAL's Regional Center for Asia and Pacific, and many, many others. The list would be too long, but a warm welcome to all of you for this event. By very brief way of background on ADB, ADB is, of course, a multilateral development bank. We have 69 member countries, and really our fundamental aim over our nearly 60 years of history has been to foster inclusive and sustainable development in the Asia Pacific region, in particular in the 49 developing countries that we have here in the region. And we focus our assistance on them, but it's not just about financing and lending money. Of course, we do that, but we are also a knowledge partner, and we hope that we can bring not only financing, which is critical, but also capacity building, sharing best practices, technical assistance. And it's really in that context that I'm so delighted that our law and policy reform program, which is headed, by the way, by Christina Pak, one of our senior counsels over there, and I know you'll be seeing a lot more of Christina in the coming days at this conference. We have been working with so many of our developing member countries in the region to do exactly that, help to improve capacity for their legal systems, and that very much includes in dispute resolution. Now, let's talk a little bit about ADB's investment in dispute resolution just to set the stage here. ADB views effective dispute resolution really as critical for assisting our developing member countries in achieving inclusive and sustainable development. It's not just a nice to have, it's really something that we see as critically and integrally linked, to that goal. Because we believe that effective and efficient dispute resolution fosters direct investment, cross-border trade, private sector and PPP development, and even climate finance and investments in the digital economy. And in fact, we look beyond these strictly economic criteria to look at social criteria, investing a lot, for example, in judicial capacity building and even the capacity building of other justice organizations in, for example, minimizing gender-based violence in some of our countries in the Pacific. So a wide range of activities that we've been involved in. So for this reason, ADB, through our law and policy reform program, really has supported various dispute resolution initiatives in the Asia Pacific for well over a decade now. Just has become an example of our judicial capacity building that we have been working with judiciaries in the effective and efficient adjudication, not only of commercial disputes and the recognition and enforcement of foreign arbitral awards, but also in environmental and climate change disputes. And as I mentioned, gender-based violence cases. And we've been assisting with the establishment and operationalization of domestic and international commercial courts. And we're delighted to have a number of you who are here from those kinds of courts that have been set up in other countries. And we really are looking forward to, over these 2 days, a tremendous dialogue on this. Now, international commercial arbitration plays a key role in reform and capacity building in that area in our developing member countries is going to be absolutely fundamental. And I think that it's going to end up attracting foreign direct investment and cross-border trade if we can get that right, if we can help create the right climate for that commercial arbitration reform. Now, initially, we focused on the South Pacific region, as it was one of the last regions in the world really without clear legal frameworks to resolve cross-border commercial disputes through international arbitration. And it was especially important for these smaller countries and economies that they have equal access to international arbitration, given what a huge role FDI plays in their economic development. Now, in 2016, ADB approved a technical assistance project to assist these Pacific developing member countries and also Timor-Leste. And in fact, we really wanted to focus on and help them accede to the New York Convention, to put in place some implementing rules around arbitration law, and to provide, and this is critical, provide capacity building for judges, for lawyers, and for the private sector. And I think the thing that I'm going to come to here is that while passing the right laws and having the right frameworks on paper is extremely important, it's necessary but not sufficient. What really needs to also happen is the uptake, and that really comes from the private sector having faith and credibility in the mechanisms and having the capacity building for all the elements, judges, lawyers, private sector. So when we started our work, it was quite remarkable. Only 3 out of the 14 South Pacific countries were signatories to the New York Convention, and most did not have any international arbitration laws in place. And it was a similar case for Timor-Leste. Really there, they were trying to diversify the economy with ambitions to join the WTO and ASEAN, but no real legal framework for arbitration. So we wanted to really change this. And Fiji was one of the early movers in enacting international arbitration reform. It had signed on to the New York Convention in 2010, but needed to enact the implementing law. And that's where ADB came in. And in partnership with UNCITRAL, we assisted the Fijian government to enact international arbitration acts based on the UNCITRAL model law and with best practices adopted from other countries abroad. So starting from that example, we then went on and helped Papua New Guinea, Tonga, Palau, and Timor-Leste, all of them to accede to the New York Convention and to enact enabling laws which would actually help establish the arbitration law regime. And they were also based on UNCITRAL's model law and international best practices. So you see the partnership with UNCITRAL has been very important in terms of promoting the harmonization, because of course it's not only helping one individual country, but helping to move the region toward some harmonization, which makes it a much more attractive environment for those sharing of best practices that lead to more inbound investments. So if you think about it, over that relatively short period of time, within a decade, this region, which had been one of the furthest behind in terms of having a fully established legal framework for international arbitration, actually leapfrogged into having one of the most advanced international arbitration legislative frameworks in the world. Now, other than our own Asian DMCs, countries in other areas are putting in place, implementing an international commercial arbitration laws for the investment climate, not just in the Asia Pacific. We've worked with other DMCs. For example, the government of Uzbekistan has been assisted by us with drafting a law on international commercial arbitration, which was enacted in 2021. And we're continuing to assist other countries to update their arbitration laws in line with international best practices. Now, of course, effective implementation of arbitration laws is equally important. So ADB has been supporting capacity building of judges and the legal community. And we've also supported the development of knowledge resources, such as the recently released International Commercial Arbitration Handbook for Judges, which is published on our LPR website in English, Uzbek, and Russian. And we've done this in partnership with the Uzbekistan Supreme Court, as well as convening knowledge sharing events to enable stakeholders to stay abreast of developments. And again, this is not a sort of once and done effort. This is something about continual capacity building, continual education, and we as ADB and ADBI really want to look to be there for the long course. Let me speak very briefly about one particular subset area which has become very important, which is investor-state disputes. This is another critical area of investment for ADB. And we really want to strengthen our knowledge about international investment agreements and investor-state disputes, since these can become, very potentially contentious and certainly very important. Over the last decades, Asia and the Pacific region has seen an increase of these IIAs with the goal of promoting cross-border trade, FDI, and regional economic integration. But they pose significant challenges and risks for developing countries, especially in the context of the evolving landscape of international investment regimes, including some of the ongoing reforms to dispute resolution mechanisms and efforts to advance the Sustainable Development Goals. So in the context of all of these challenges and to assist our developing member countries navigate this increasingly complex area, we basically have launched a technical assistance program in 2023, which is really targeted at providing the capacity building to multiple stakeholders involved in really the basic stuff: drafting, negotiating, and implementing international investment agreements, and government lawyers and other officials charged with managing and handling disputes, making sure that they are, trained up on some of the issues that are happening around the world in these and get the training they need. Now, let me move as just sort of a last few thoughts to mediation, and particularly the Singapore Convention. I've had some early chats before the meeting started with a few of you about, the Singapore Convention, and I really think that this is an incredibly welcome option in our toolkit of dispute resolution, because there's a growing and I think unique value of mediation. In fact, mediation, when you think about it, is embedded in the culture and the legal systems of many of our ADB developing member countries in the region. Like, speaking as an American lawyer, there's always a tendency, oops, go to court, litigate. It's the first idea that comes up, and the idea of like a more, well, let's talk about this. Let's see what our, what our problems are. Maybe we can work this out without these events. But that's something that I think is part of the culture in a number of our member countries. And more importantly, businesses also see the benefits and the opportunities for mediation, both in the commercial realm as an option, but even in investment disputes with the state. And parties need to remember that the broader purpose of mediation is to make international commerce better. It's really that simple. Businesses do not want and often will not accept the risk of long, drawn-out processes to basically resolve their disputes. Now, with the Singapore Convention, should the parties choose mediation as an option, and depending on the subject matter and the relationship between the parties, there will be, I believe, more confidence that international commercial mediation settlement agreements will be enforced globally. Mediation, I think, is because of that becoming more of an integral part, really more of an integral part of arbitration and litigation, the three of them together. And parties have to use multi-tiered, sometimes hybrid clauses. I'm not sure this would work in your contract with your landlord, Dean Sonobe, but certainly in other cases, using multiple hybrid clauses that although if one is going to adopt this type of clause, they need to use it properly and be mindful of some of the jurisdictional challenges. But the point I think that we will want to explore here during these 2 days is thinking about how mediation can really encourage early dispute management and intervention. And I think, it's easy to look at mediation and say, here's a path, here's what we're going to do. But we should also be thinking about the incentives that puts on the party to try to resolve things earlier. I think we'd all agree that it's better to try to resolve these disputes earlier. And if they can be resolved earlier, it results in better investment promotion. It requires parties to identify who the stakeholders are and really move to dispute resolution earlier in the process so that hopefully the potential investors are not lost. Now, the uptake of the Singapore Convention has been good with ADB developing member countries as well as their trading partner. But once they sign on to the Singapore Convention and ratify it, countries with dualist systems will need to put in place national implementing laws. And as I've said to a few of you, before the meeting, ultimately, uptake of mediation, as good as the laws might be on paper, are going to depend on the international business community and the effective implementation of the convention in national law and practices. So in conclusion, I would just like to say that ADR, as we know, has proven to be an agile and able form to evolve with the changing development landscape. It can also fortunately be tailored for different types of disputes and contexts. And given its significant positive development impact, which is one of the things we care most dearly about as ADB, ADR in its many forms should be further developed and supported in Asia and the Pacific. So in this regard, I'm just happy to underscore how keen ADB is to continue to play an active role in such a space and to assure you that our legal department will be strongly supporting this together with our dear friends at ADBI and all of you in this community of ADR supporters and practitioners. Thank you so much for being here. It's an honor, and I look forward to engaging with you over the next few days of this conference. Thank you very much.
Thank you, Mr. Clark, introducing ADB initiative and encouraging our future endeavor. And next, I will introduce the Assistant Vice Minister of MOJ Japan, Yoshiyuki Tsutsumi. Mr. The floor is yours.
Mr. Sonobe Tetsushi, Dean and CEO, ADBI, Mr. Thomas M. Clark, General Counsel, ADB, Ms. Anna Jovan-Bre, Secretary, UNCITRAL, distinguished participants, good morning, everyone. I am Tsutsumi Yoshiyuki, Assistant Vice Minister of Justice of Japan. It is my great pleasure to deliver my welcome remarks for the ADBI policy dialogue on alternative dispute resolution. I understand today's event is ADBI's initiative to promote international mediation in Asia and the Pacific region. I would like to express my gratitude to the ADBI, ADB, and UNCITRAL for organizing today's event, and it is a great honor for the Ministry of Justice of Japan to take part in this event. The Ministry of Justice of Japan has been undertaking an initiative called Justice Affairs Diplomacy, which aims to promote values such as the rule of law and respect for human rights in the international community. In an era where global trade is rapidly expanding, ensuring a stable and predictable legal environment is more crucial than ever. To promote such environment, we need legal frameworks which are not only well structured but also adaptable to the evolving global landscape. Such legal frameworks would allow businesses and individuals to rely on clear and consistent rules for facilitating smooth transactions across borders. We also recognize the increasing importance of international arbitration and mediation as a means to resolve disputes efficiently and fairly, ensuring that businesses and individuals can operate with greater confidence. As such, Japan is committed to taking the initiative in invigorating international arbitration and mediation as part of justice affairs diplomacy and has implemented various activities. However, we understand that such efforts cannot be achieved in isolation. For this reason, Japan is actively collaborating with various stakeholders, including governments, international organizations, and legal experts, to enhance not only the development of international legal frameworks, but also their proper operation. Among others, UNCITRAL has been our great partner in promoting these activities, focusing on legislative work which Japan has strongly supported. At the same time, we are pleased the ADBI has become our new partner, which has demonstrated a strong commitment to advancing alternative dispute resolution mechanism across Asia and the Pacific. Also, practitioners and businesses play a crucial role. Their expertise and experiences ensure that the international legal frameworks are practical, adaptable, and responsive to the needs of the global market. During this 2 days event, there are 8 sessions focused on mediation. What makes this event particularly valuable is that the speakers come from various countries and diverse backgrounds, including government, private practice, arbitral institutions, and academia. I'm convinced that this diversity will enable us to gain a deeper understanding of mediation from multiple perspectives, allowing us to explore its various applications and challenges in different legal and cultural contexts, and thereby obtain valuable insights into ADR in Asia and in the Pacific region. I'd like to conclude my remarks by wishing you all continued success in your future endeavor. Thank you very much.
Thank you for your warm remark, Mr. Chitsumi, and we want to appraise especially appreciate to Minister of Justice Japan for their effort to helping us building a partnership with many Japanese institutions. And lastly, we will deliver the welcoming remarks from Ms. Anna Jobin Brett, Secretary of UNCITRAL, delivered online.
Sushin Sonobe, Dean and CEO of Mr. Tetsushi Sonobe, Dean and CEO of ADBI. Mr. Thomas Clark, General Counsel, ADB. Mr. Yoshiyuki Tsutsumi, Assistant Vice Minister, Ministry of Justice of Japan. Professor Rajesh Sharma, Professor Noyoung Park, Justices, distinguished speakers, and participants. A warm welcome from the United Nations Commission on International Trade Law, located in Vienna, Austria. It's an honor to deliver co-opening remarks for the ADBI Policy Dialogue on Alternative Dispute Resolution, Disseminating International Mediation in Asia and the Pacific region. My special thanks to the ADB Institute, to the Asian Development Bank, and the Ministry of Justice of Japan for this privilege and for the strong collaboration with UNCITRAL to facilitate trade and enhance access to justice dispute resolution across the region. While I regrettably cannot join you in person, my colleague Akita Kominder, head of the UNCITRAL Regional Center for Asia and the Pacific, located in Incheon in Korea, is joining you here in person and stands ready to answer all the questions you may have about the work of UNCITRAL in the area of mediation and other UNCITRAL work and learning tools. Mediation is being promoted globally, but the concept of mediation is not new in Asia. Informal mediation has been practiced in this region for a very long time. So it is with great pleasure that I acknowledge the participation of so many countries from the Asia-Pacific region, ranging from the judiciary, government agencies, public entities and ADR centers, legal experts, and academia. This speaks to the broad regional interest in peaceful means of solving disputes promoted by the UNCITRAL mediation framework, and particularly by the United Nations Convention on International Settlement Agreements resulting from mediation, commonly known as the Singapore Convention on Mediation. Turning to the Singapore Convention now, it was adopted in December 2018 by the United Nations General Assembly, which expressed its conviction that the convention would contribute to the development of harmonious international economic relations. In addition to being a landmark achievement in long-standing involvement by UNCITRAL in mediation, the convention is also the first treaty in this field, bridging legal systems and reflecting a worldwide consensus beyond cultural differences. Most significantly, it brings what was missing in the international framework on dispute settlement, an effective mechanism to enforce international settlement agreements. This contributes meaningfully to the achievement of the Sustainable Development Goals, particularly SDG 16, which is the promotion of access to justice and governance in accordance with the rule of law, and furthers the development of a mature, rules-based global commercial system. As you will hear from many experts on the benefit and technical aspects of the convention over the next 2 days, let me briefly provide you some updates on its uptake. As of 23 January 2025, the convention has 57 signatories and 15 parties, with Israel having most recently ratified the convention on 8 January 2025. I like to say that this is a very successful convention that sells like hot buttons. Of the current 57 signatories, 22 are in the Asia Pacific, with half of the ASEAN member states, Brunei Darussalam, Laos PDR, Malaysia, the Philippines, and Singapore, having signed the convention when it opened at its signing ceremony on 7 August 2019. Nearly half of the 15 state parties are in the Asia-Pacific region, in alphabetical order: Fiji, Japan, Kazakhstan, Saudi Arabia, Singapore, Sri Lanka, and Qatar, with many others taking steps towards becoming a party, such as the Laos PDR, the Republic of Korea, and others. In other regions, such as Latin America and the Caribbean, many countries have concluded the parliamentary process and are ready to join, such as Colombia, Costa Rica, and Paraguay. It is my hope that many states will adopt the Singapore Convention on Mediation and thereby contribute to further strengthening the rule of law, the development of international trade, and sustainable development in all regions. The UNCITRAL Secretariat stands ready to assist governments in these ongoing efforts and all other areas of UNCITRAL's work, including by reviewing draft legislation to adopt UNCITRAL instruments if so requested. I'm also delighted to see the topic of mediation in investor-state disputes on the program. This is most timely as UNCITRAL adopted the UNCITRAL model provisions on mediation and the UNCITRAL guidelines on mediation for international investment disputes, most recently in 2023, with the aim of encouraging the use of mediation for resolving international investment disputes. Recommended for the inclusion in investment treaties, the UNCITRAL model provisions on mediation allow parties to exercise control over the mediation process, to reach a self-tailored outcome, and to preserve their relationship. The UNCITRAL guidelines on mediation for international investment disputes provide practical guidance to parties on the use of mediation by listing and briefly describing issues that should be considered when undertaking investment mediation. Both texts are freely available on the UNCITRAL website in the 6 United Nations languages, as well or together with all other UNCITRAL texts. The adoption of these texts comes after several years of preparation by and discussions at UNCITRAL's Working Group 3, which was entrusted in 2017 with a broad mandate to work on the possible reform on the investor-to-state dispute settlement. As representatives from many states are here, I take this opportunity to highlight that in July 2024, the Commission adopted, albeit in principle, the statute of an advisory center on international investment dispute resolution as one of the elements of investor-state dispute settlement reform. A few aspects of the establishment of this center, particularly where and how, do still need to be discussed and to be operationalized. But once established, it is expected that this advisory center will provide training, support, assistance, and legal representation with regard to international investment dispute resolution, thereby enhancing the capacity of states to prevent and handle international investment disputes, and this is particularly relevant for least developed and developing countries. Since the establishment of the advisory center would require further preparatory work, the Commission initiated an informal process to tackle certain issues and recommended that governments and regional economic integration organizations interested in the operationalization of the advisory center actively take part in this process. The UNCITRAL Secretariat is committed to finding global solutions to further advance these issues and counts on the support of all contributors. The first advisory center operationalization meeting took place on 2 to 4 December 2024 in Bangkok, Thailand, with the next meeting expected to be held in Yerevan, Armenia. And I hope to see many of you taking part in these operationalization meetings. Thank you again to the ADB Institute, the Asian Development Bank, and the Ministry of Justice for the honor of addressing you today. I wish all participants a most successful policy dialogue. And for those of you who want to delve more deeply into the anti-trial mediation framework, I also encourage you to take the online courses designed by the Anti-Trial Secretariat with the support of the government of China to familiarize themselves with the framework in its entirety. So with these few words of co-welcome, for which I'm very grateful, I wish you a very successful conference and hope to see you all live soon. Thank you.
Thank you for your welcoming remarks, Dean Sonobe, General Counsel Clark, Assistant Vice Minister Chuchumi, and Secretary Jobin Brett. Ladies and gentlemen, please join me a big round of applause for them once again. Yeah. And now I'm happy to introduce our keynote speaker, Professor Rajesh Sharma, Professor of Legal and Dispute Studies at RMIT University and Director of RMIT Dispute Resolution Center. The floor is yours.
Good morning, everyone. Before me, all the distinguished speakers who came before me, they have already given you the key points. So I don't have to add anything. I just have to say I concur with them, and that will be sufficient to start with. First of all, Dean Sonobe and Deputy Dean Zhang, Mr. Clark, and Honorable Minister, thank you very much for inviting me here and giving me this floor. It's really an honor and an opportunity for me here to share my thoughts. But I see the time, and I promise that I will try to finish it within time so that I match up with the Japanese time rather than you say that I'm following some other time. My simple message to you is that our quest for providing access to justice through mediation or through ADR, how far we have reached, how far we have to go, and what we have to do next. So what is our like expectation, and what is our access, and what is our excellence, and how we can reach there? That's my idea, and which I want to share. But before where I should click? Yeah. Okay. So please help me with the moving the PowerPoint, okay? When we started mediation, it was always considered as a poor cousin of lawyer, because when we were saying I'm mediator, people will say that, okay, you are mediator, but what do you do? Like, apart from that. And it was always considered that the lawyers, half of the work or some of the work lawyers do as a mediator. So the lawyers and the mediators, they were very much connected. And the mediators were never considered as a profession by itself, and never considered as a vocation or profession or a service like that. But over the years, we have seen the changes, and we have seen the changes coming so well and so fast that at least for last 10 years, what I'm witnessing in my place is that we are getting young generation and coming and saying that I want to be in the legal field, but I don't want to be a lawyer. And they are coming out as a mediator. And this year, last year, we had the youngest mediator produced in Victoria, only 21 years old, and they are very happy and working over there for this purpose. So now we can take mediation as our profession, and happily we can have our name card and give it to them that I'm proud mediator, and you should feel very proud about it. So the next slide. So later on, what happened that when we were working with the IORA group, the Indian Ocean Rim Association group, and that was started in 2016. Very similar time when Singapore Convention was starting at that time. We were asked to develop a center for excellence and helping 23 countries. When we looked at it, we started as a traditional model that we have to look at, democracies, rule of law, all those things will help the countries to become a destination for investment or ready for the business. But then we realized that if we follow that traditional rule or the route, it will not help us. So experts, they come up with the idea to give a jump start to any country. We are coming with, and we suggested that any country which adopts the 5 kinds of instrument or the law, then they will be ready to start an attracting business. In that one, the first one is if we have UNCITRAL model law on arbitration, UNCITRAL model law on mediation, and then we have a New York Convention, and now we have a Singapore Convention. And on top, if we have a Convention on International Sale of Goods, if we have these 5, then the country is ready. And they can announce and say that we are ready to invite investment, we are ready to do the businesses, and it will provide. And we don't have to worry about rule of law or democracy and all those things. Leave it to the different level, but the business will continue. And again, that was coming from the business centers from 23 countries who wanted to have a quick system to start with. And that's the idea. So we see the ADR has become now the indicators that the country is ready for the business, and we can go ahead with that. So this is my message to all the government representatives who are here. They can follow that. Next, Singapore Convention has definitely given us a very good impetus to move the mediation forward, and that has come forward in that one. I was certainly not alive when the New York Convention was signed in 1958. Many of you might be there, but I was certainly not there. But I was very excited to be here for seeing this development of the Singapore Convention and the signing ceremony in Singapore. That was very good in that one. But the Singapore Convention, people will talk about it in a different session. But when Singapore Convention was adopted, there's something else happened in the next slide. If you see, the name was very important. All the time we started, when the discussion started, we started with the word conciliation. And it was considered the conciliation is widely understood word. But in the very last session, it was decided to change the word conciliation to mediation, so that the mediation is like Singapore Convention can have a better, access and better spread because of the word mediation. And around the world, it was accepted that the mediation is better understood and widely understood word, which was not there when we started the UNCITRAL rules on conciliation in 80s, or in 2000 when we have a model law on conciliation at that time. So the names were changed at that time, and it become, so the name does matter, and it does happen that. So if you go to the next slide, Singapore Convention itself is there, but there's a one thing, and I really feel sorry for Mr. George Lim, that just because the name is Singapore Convention, everybody thinks that it is his responsibility and the Singapore's responsibility to make it success. But that's not correct. Please, we all have a shared responsibility to do that. And the reason I'm saying the adoption of Singapore Convention is a one part that Mr. Clark was saying, that having a law is not important. How to implement and going forward is more important. And for that, we have to think about that government level, the UNCITRAL level, we have done the work, we have finished the work, and we are very happy with that. But even during the drafting and deliberation, it was understood that the professionals will come forward and take care of the unfinished work. And there are a couple of unfinished, there are many, but a couple of things I would like to highlight is that the mediation standard and the mediators standards. Conflict of interest, these two can be a ground for resisting enforcement of settlement agreement. But do we have any consensus on that? I believe we do not. And I give you one example. If as a mediator, if I do a private session with my client on coffee or breakfast or lunch, is it acceptable to you? And that is not very clear. Though we said that every country has a mediation standard, mediator standard, but we never come out with any universally accepted principle. Same with the conflict of interest. We know in arbitration we have conflict of interest. IBA gave us the guideline, but the conflict of interest in mediation is different, and we have to start, we have to think, and we have to draft a rule for the conflict of interest related to mediation. And that is not the job of UNCITRAL, it's the job of the media professionals. We have to come together on that. So the next part, if you look at that, so my direct submission to you here is that, can we finish this unfinished work? My answer is that yes, we can do it. But then why? It is already 5 years. Why we have not done it? Because we are working separately. We are working independently. We are working in our own areas. What we need is a cooperation. What we need is an alliance. We need some kind of a cooperation, collaboration, and coordination. And ladies and gentlemen, all the mediators who are experts, I'm saying is that now it is time for us to practice what we are preaching or teaching in our centers during the mediation. That's the time we have to come forward. But this alliance and cooperation has to be done in a balanced way. It should be inclusive. It should give opportunity to everyone, whether it's a centers or individuals who want to be part of that in this movement, they should join. And therefore, we need an international, some kind of independent, objective, neutral organization, reputable organization, which can provide this platform. And I see that ADBI, ADB, they can be one in Asia, and we should take opportunity to that. If we do that, then what will happen? We can ask the government and all the representatives here from the government. I will say that signing of Singapore Convention should be the most easiest part, because there's no landmine or there's no problem, there's no legal problem in this draft, in this law. We can definitely adopt it. At least we start with the signing of it. Waiting will not help. But even the government has so many things to do, how they can cope up with that. And for that, we need the local professionals to come forward and help them and move this idea behind or forward. One example I give you, the Papua New Guinea has been talked about quite a lot. In 2019, Justice Wood is here. When we were there at that time, the countries like Fiji, or Papua New Guinea, or look at Samoa, Palau, those members were there, but they had no idea that in UNCITRAL, we already have a Singapore Convention. And when we discussed, immediately they worked it out. By August, when they reached to Singapore, they all signed that, most of them. So similarly, December, in Nepal, we organized the first ADR, and our colleagues from Nepal is here. I see the Prime Minister coming to inaugurate the session, and the Prime Minister came and he said that Nepal is ready to sign the Singapore Convention. So this is the cue for my colleague from ADBI and ADB, that if you give them little help, Nepal, Bhutan, and I also understand Papua New Guinea is ready to sign the Singapore Convention. We just need to give help, and similar help is required everywhere. So if the government and professional body, because the government has to rely on the professionals, and the professionals can help the government, and the government can take advice from professionals, and then we can move forward and signing this Singapore Convention, and then we follow through the adoption and implementation part, that we can do it. So if you move forward, I can also say that what is required in the Singapore Convention, that we have to also work with the judges and the court registrars. We did some workshop with them, and it was interesting to see that if you give a draft of agreement to the judges, and we run through them, that if this comes to you, how you are going to implement it or enforce it in your court, we were very surprised. The conclusion which came on the same set of text, and that was eye-opener for us. And that also tells us one thing, is that judges, just by reading the text of the Singapore Convention, will not be able to interpret properly. And in order to interpret properly, we need to give them the drafting history. UNCITRAL Secretariat has prepared the drafting history, but that is not the complete one. What we need is a transcript of the discussion which has happened. And I can say that with help of my students and others, we have already completed this work, and we only require some technical solutions, technical permissions. Once it is there, it will be available for everyone to use, and the judges can also use that. Next. For the businesses, I see that the major users or the main users of Singapore Convention or the mediation as such is the businesses. It's very wrong that we are focusing only on the lawyers. Lawyers are not our main users. It's the businesses who are main users. And Professor Nguyen Park in Korea, he has given us this example. KIMC, Korean International Mediation Center, is not registered with the Ministry of Justice. It is registered with the Ministry of Commerce. And that means we have to focus on the commercial parties, because they are the users. So a small and medium-sized enterprises will be the real users and the beneficiary of Singapore Convention, because the multinational companies, they have enough resources to manage it before, even now, and in future. But what is required is the MSMEs, they require our help, and the Singapore Convention can be a one example for that. If we go next. So far as this one is concerned, 5 minutes, enough time. I'm a lawyer. If you don't pay me, I will not speak extra. Now, for the training part, and that is very core for me, is because I put on my hat as a teacher, and I find that the good training and the good teaching in this area is very helpful and very useful. Now, very simple thing you see, even before Singapore Convention, all the mediation trainings were done only for 30 hours, 36 hours, 40 hours. So if the Singapore Convention has changed, still the trainings are going on 36 hours, 40 hours. So what changes has brought? It means even in this training, we are not including the education and training on the Singapore Convention. I suggest that we have to add this extra 10 hours on that one. And we should do it. We have already started. Some institutions have started, but we have to. Another thing is that every institution, I know for some institutions, some individual institutions, training is a bread and butter. But what is required for real development is that we need to make it available to everyone. We have to give a quality program to everyone, quality teaching and training. And for that, our cooperation, our alliance, learning from each other will be very useful for us to follow on that one. And we suggest that we need a training material, well designed, well drafted, based on technology, which an individual or people can access it at their own leisure, at your own time, and they can learn by themselves. And by technology, it's possible. And if we design that, put it on the platform, and most importantly, if we provide them for free, then that will help us in many countries where people do not have enough resources. They can get a quality training program in that one. A long time back for arbitration, UNCTAD did it, but later on the project collapsed. But this, we can do it, and ADBI can help it in that one. But before we do, I have one request for all the governments and the institutions and all our colleagues who are involved in the training program, that please include all the people who have even disability, to include them in our training program. It took ICC 100 years to think about that. People with the disability should be involved in arbitration, and they only come up with the task force and the guidelines after 100 years. But for mediation, we don't have to wait for that. And I know because I was there on that task force. So I suggest that the same guidelines can be used, because we have expanded the scope. It's not only for arbitration and ADR, and that we should include. And we suggest that we have to start including them and all those things. So disability inclusive training program should also be included in that one, and it is possible. Next one. For the new development, I see that for all the people who are involved in that one, I already said that we have to adopt the 10 hours for Singapore Convention, where we teach them that convention, what the convention is, but we also train them that how you use it, how do you interpret it. And particularly for the judges, registrars and all, we have to involve them. For mediators, we have to tell them about the drafting, how to draft that in compliance with the Singapore Convention, or avoid the mistakes which can be caught later on, or the judges may take it in a different way. We should do that. And for lawyers particularly, we have to also teach them the mediation advocacy, how to behave like a lawyer in mediation, not to behave like a lawyer in court. There are two different forums which they need to understand, and we have to do. Another significant development is coming because the third-party funding in arbitration has come up. So they are also sitting in the mediation, but we are not looking at them. We have to have some kind of guidelines for them, some kind of a strategy for them, that how to involve them. So what I see is that if we have that kind of a training program, and if it is put on the platform like ADB or ADBI platform, then that kind of independent, neutral a platform where people will register and complete the course, get a quality training program, then what will happen? Their name should automatically come on the list. And even otherwise, ADBI or ADB should prepare a list of mediators from Asia. I'm not saying Asian mediators. I'm saying the list of mediators from Asia. We need that. UNCITRAL 10 years ago, they started this program, but it will fizzle out somewhere else. We have to pick up that, because that will acknowledge the talent and the resources and expertise of Asia. Since we are in Asia, we can start from there. So that's why my proposal is that. Next. Why we need that? If you see this diagram, this is anybody who has this is like, considered as a doctor. A doctor is trained in any language, any culture, any place. They know how to work it out because human beings are same. So if human beings are same, doctor can save everyone. So ADR skills are that universal. It can be used anywhere, in any culture, any civilization, any language, anywhere. And that kind of a good training can have a global ADR experts prepared from here. Even within Asia, we can do that. And why we are doing it? Because major future, Anna has already told you, many mediations are coming and the many experts are needed. Whether we look at ISDS, whether we look at WTO, whether we look at ICSID, whether we look at WTO, we look at International Mediation Organization, or we look at even the Belt and Road or even the IORA group, where the maritime mediation, yes, maritime mediation is going to start, which has been untouched area, and this is coming. So we need more people on that one. So my final thing is that people, you may say that I have said so many things, we have to do so many things. Can we achieve it? And my simple idea is that, or my simple feeling is that, if we really have a passion about mediation, we can do it. So make mediation your passion, not a fashion. If you take it as a fashion, it will not work. But with passion, it will work. We can coordinate and collaborate, and we can do it. And ADBI can help us in organizing all those people together so that we can work together. We have experts here, and I'm sure that can be one key point from here. So many things have to be done. So many unfinished works are there. And that's why the famous poet says, miles to go before I sleep. I said, no, not me, not alone me, we all. So miles to go before we sleep. Thank you. Thank you very much.
In session 1, how international ADR could be a future game changer, importance of international ADR in the real world and current global landscape. And to lead this discussion in session 1, I am pleased to have Dr. Byung-Sik Jung, Deputy Dean, ADBI, who made a great contribution to make this conference. And as the moderator, Dr. Jung, the floor is yours.
Thank you. Thank you so much. Before coming to this office, I pray to God. This event should be the place to learn each other and encourage each other and make some commitment for the next step. That's my goal. I felt the first my prayer is working now because I touched and moved by the Rajesh's presentation. Thank you so much. With that, building on his presentation, let's proceed our first session. In the face of geopolitical tension, growing fragmentations, the regional economic cooperation and integration become even more crucial. Under this circumstance, alternative dispute resolution could play a critical role in facilitating trade and investment. Actually, that is really lead to regional economic integration. It is known that ADR is a favorable dispute resolution mechanism, which give many benefits in terms of cost, flexibility, and effectiveness compared to traditional litigations. In this session, we'll delve into the merits of ADR in the context of trade and investment. Thomas mentioned that ADR contribution to trade and investment is significantly. Let's see. The main reason of this session is to give developing countries some kind of confidence. There is a benefit of the ADR. Therefore, they are encouraged to take this ADR in their legal system. That's our this session's purpose. Additionally, we aim to explore ways to facilitate ADR across the Asia-Pacific regions. To start, let's invite Dr. Naja Alexander to present the landscape of ADR, supported by statistical insights. We are students to know the fact with the number, critical statistic. She will show the statistic to prove the merits of ADR. Floor is yours.
Good morning, everybody. I'd just like to start by thanking the ADBI team. It wasn't easy for me to get here for administrative reasons, and they were pragmatic, committed, responsive, problem solving, everything that good dispute resolution practitioners should be. And I wouldn't be here if we hadn't all thought naturally. So thank you very much, all of you. So what do we know about mediation and arbitration practice? What do we know from the user's experience? And by users, I mean, you can hear me on the microphone? Yeah. By users, I mean end users, client users, but also professional users, such as lawyers in house counsel, but also external lawyers. How do they decide which dispute resolution mechanism to use? What's important to them? And to what extent are they happy with their experiences? And why, right? Now, many of us, if not most of us in this room, have our own experiences and our own stories, and they're important. They offer richness to the practical experience, and I'm sure the panelists here will share many of their stories. What I've been asked to talk about today are some of the findings of a survey that we run at SIDRA, Singapore International Dispute Resolution Academy, and we've been running it over the last 8 years. Let me just tell you a bit about it. I'm only going to pull out some highlights that are relevant to our discussion today. And I think when you've got some statistics, then when you add the stories, right, you get a much fuller, richer picture, not only of what's happening, but what needs to be done in terms of policy. Now, clicking. Where do I point it? Oh, I point it here. Oh, here. Now, Raj got it. I need to be able to figure it out. Oh, it worked. Was that the right one? Yeah, I went too far. All right, so let me tell you a bit about this survey. This survey is 100% user-centric. We only ask people who've used a particular dispute resolution process. If you haven't used it, you don't answer the question, right? So it's based on actual experiences. It only focuses on cross-border disputes, cross-border commercial. We also have some deeper dives into intellectual property, into technology disputes, into ISDS. I can't go into all of that today, but it's all available online if you are particularly interested. It's distributed in all of the UN languages. And we look at a range of dispute resolution processes: arbitration, mediation, litigation, and also hybrid mechanisms. I'm going to pull out some findings mainly from mediation and arbitration, right? But no, there is this breadth and also depth if you're interested. So this first slide asks, well, you know, when you resolve disputes, cross-border, commercial, what do you use? No surprise here. International commercial arbitration comes up number 1. Litigation, number 2. And then we've got 2 here. We've got fairly tied hybrid dispute resolution, which is defined as involving mediation and arbitration at least, and mediation. Now, if you add up, right, a bit of maths before lunch, if you add up hybrid and mediation, you will find that at least in these statistics, it's slightly higher than international commercial litigation. And what does that say to me? It says to me that when we're looking at mediation use in cross-border disputes, we need to look more than at standalone mediation. We also need to be looking at hybrid or mixed mode protocols, because there is a lot of mediation happening in that space also. The Singapore Convention, of course, doesn't cover mixed mode, right? It only deals with standalone mediated outcomes, but practice is certainly much broader. Just quickly, IP disputes, and we'll see technology disputes. We ask people, have you been involved in resolving matters before court? Overwhelmingly, yes. And I haven't got this slide, I think, up. Technology disputes, overwhelmingly, yes. We resolve before we get to litigation. Again, cross-border matters. And this slide isn't here, but in both of those, mediation featured. With technology disputes, I think it was mediation and arbitration, and with IP disputes, mediation was the #1 use, and then litigation, and then arbitration. And there's technical reasons with intellectual property why arbitration, but certainly not why mediation, but why arbitration might be less popular. All right, so when people choose mediation, I'll get to arbitration in a second, what's the influence, right? And I think this is a critical point for making policy, all right? Earlier this morning, Thomas talked about not just having the legislation and the infrastructure on paper, right? But having the capacity building and having the stakeholders, institutional and individual, doing things. Well, who makes it happen here, right? Nearly 70% said the lawyers, right? The lawyers advised us to go to mediation, right? 50%, it's a lot, contractual obligation. So you're finding more mediation in dispute resolution clauses, not always standalone, often in mixed mode clauses. And #3, I thought interesting, 1/3 of people, now these would be fairly sophisticated clients, I grant you, but still asking for mediation. Arbitration, a similar story. The statistics are a little bit different. Contractual obligation, 90%, but also lawyers' advice and clients' request, right? So when we're thinking about policy, you can have a Rolls-Royce law, right? And a Rolls-Royce set of rules, right? But you will never get that Rolls-Royce onto the dispute resolution road, so to speak, right? Unless you have a pathway, unless you have influences and triggers, right? And we'll look at that a bit more deeply as well. It also shows the importance of lawyers, not just in advocating mediation or arbitration, but also in drafting clauses. For ISDS, again, not dissimilar. The clauses would trigger it, contractual obligation, and external lawyers' advice. All right, so what this slide shows, here we ask people how important they thought particular factors were in choosing a particular dispute resolution mechanism, and then how satisfied they were with it. Now, this one just shows the satisfaction. Again, all of these slides, there's hundreds of them that are written in a report that's available online if you're interested, but just have a look at this. Now I can't see this far, but I think the brown, yes, the brown going from the left, the dark brown is mediation, arbitration in the middle, the pale one is litigation. So visually, what do you notice? That in a couple of spots, you've got much lower satisfaction in arbitration and sometimes much also lower satisfaction in litigation compared to mediation. Cost, speed, right? No surprise. With litigation, it's also confidentiality, of course. Litigation isn't meant to be confidential, but also this very important piece of preservation of business relationship. Right now, admittedly, I haven't shown you this slide, but the expectations weren't particularly high that if you go to arbitration or litigation, you'd preserve your business relationship. But certainly the satisfaction wasn't there either. Again, a snapshot. I find I've got two of these quadrants, one on mediation, one on arbitration. Notice just the top right corner, right? High importance and high satisfaction. That's when people said, we wanted to go to mediation for these factors, right? And hopefully you can read some of those factors there. And we were satisfied, right? More than 50% said, and we were satisfied with those factors. So really drilling down, right? And let's see. There's one that I can't read now. That's right, transparency, low importance, but high satisfaction. That was a nice surprise, but really nothing in the low importance, low satisfaction box. So what that means is that where people use mediation, they are by and large happy with the experience. It doesn't mean you don't need your influences, right? You still need to trigger people there, but by and large, they're happy with that experience. What about arbitration? Also, by and large, happy with the experience, top right quadrant, but as we saw before, a few in the low satisfaction, either high importance, cost and speed, right, are very important, but there were low satisfaction. Political sensibility on the border there. And the lower left quadrant, preservation of business relationship and indirect costs to the client. So there weren't big expectations there, but they also didn't get a lot there as well, right? Low importance and low satisfaction. All right, I'm just going to, oh, right, hopefully you didn't see that. Now I've got a question for you. All right, over the years, you've got to answer true or false, right? And you've got to tell your neighbor, right, the answer to this question. So true or false. So over the years, do you think that satisfaction, people's satisfaction with the enforceability of mediated outcomes has increased or not? So let's just take the statement, it's increased. Is that true or is it false? So if you think the satisfaction with mediated outcomes has stayed the same or is less, it should be false. If you think it's increased over the last 10 years, true. All right, quickly to your neighbor. I've only got 4 minutes, quick. All right, what do people think? True. Yes, a gold star for Frauke. It is true indeed. All right, so and that was this slide. So you can see user satisfaction with mediated outcomes. Has the Singapore Convention got something to do with that? I suspect probably in the broader sense of the word, not in the narrow sense, because we don't know of any cases where there's been that direct enforcement used. But in terms of people's end users' confidence with mediation, it's certainly been the case. Now, all right, I will skip that and leave that for the panel. All right, choosing mediators. What comes up time and time again for choosing mediators and choosing arbitrators are ethics and dispute resolution experience. Different from industry knowledge, also important, but not ranking as high as dispute resolution experience. And you see the same with arbitrators, dispute resolution experience and good ethics. And again, in terms of mediation, a link to the Singapore Convention. In terms of both mediation and arbitration, you know, the importance of having very clear and real, and that's a conversation for itself, real ethical standards that mean something, which is not easy to achieve. All right. Last point I want to make is about technology. So we asked people, how useful do you think technology has been, particularly in the post-COVID surveys that we did, and what types of technology did you find most useful? So again, focusing just on mediation and arbitration, what you see, it's actually relatively similar for both. People found the virtual online hearings most useful. All right, but then you see a bit of a drop off with mediation. Yes, dedicated ODR platforms, right? So dispute resolution platforms dedicated to mediation and or arbitration. Yeah, more than half of the people said we found those useful, but most people still use Zoom or Teams or something like that. All right, for better or for worse. So that's the virtual online hearing. The use of e-filing platforms, cloud-based storage systems, e-discovery. You see that. There's still awareness of that, that's still useful, but in mediation, not used as much as in arbitration, right? That's the same list, right? Virtual online hearing, dedicated ODR platform. And you see, don't worry about the different colors, that's just splitting up our respondents. But for our purposes, you'll just see in the first 4 or 5 technical elements that there is, I guess, a greater awareness of the usefulness of these specific types of technology for arbitrators. Or sorry, not for arbitrators, for people using arbitration, right? And probably, I think that's because being a decision-based process, which is typically more legalistic, people are thinking about things like cloud-based storage, e-filing platforms, etc. I don't have a slide on this last one, but one thing that came out with technology and mediation and arbitration was people thought, lawyers and their clients, it's most useful to use it in low value disputes, which is sort of interesting because I think experience shows that that's not the case at all. But that also could be an interesting policy point in terms of increasing awareness and changing people's ideas of what ODR is useful for. Last slide, a couple of critical points, I think, for ADR development, and the panelists here will debate and pull me apart on some of these. But I think ADR does not occur in a regulatory vacuum, right? There's always regulation around us, whether or not we have a law. So let's make that regulatory design intentional, right? Mixed mode dispute resolution plays an increasingly relevant role, particularly in cross-border disputes. Users have positive experiences with mediation and mixed, but still largely good, with arbitration. Triggering mechanisms, how you get people to the party, they are essential, right, for policy and law. The role of lawyers and advisors I've discussed. Ethics, we've seen as something not to neglect. The impact of the Singapore Convention, and integrate technology now. Also in your regulatory design, right? Because an e-signature, for example, would need to be aligned with your electronic communications laws, right? So some points out of that survey. I hope that was helpful. Thank you.
Thank you, Naja. Naja explained the mediation and arbitration in a hybrid format, and she emphasized that each has its unique merits, which the other does not possess. Thank you so much. And also, it's interesting that she introduced the online platform-based disputes. It's also interesting. But unfortunately, I missed her introduction of her. She's a very important person from our side because we need the numbers. ADR, the statistics, ADB really is keen about the number. She has the number, so we outreached to her, and finally she came to Japan. I'm very happy to have her. She's also currently director, a professor, Singapore-based academy. Thank you so much. Now, this is actually a presentation by the professor. It might not be reality, even though she showed the statistic, but let's listen, the real voice from the practitioners. We have distinguished 6 panelists. Please excuse me to shortly introduce you today. Mr. Steve Kim, Secretary General, Korea Commercial Arbitration Board International. Then Ms. Fei Yu, Director, China International Economic and Trade Arbitration Commission. Then Mr. Naoki Idea, Partner of Koizima Law Office, Japan Commercial Arbitration Association. Mr. Jay Shin, Secretary and Development Manager, Singapore International Arbitration Center. Ms. Lily Petrosyan, Acting Director, Arbitration and Mediation Center of Armenia. Ms. Diana Bazakova, Director, Tashkent International Arbitration Center. Thank you. Would you show the... First, we have a round, actually 2 rounds of discussion. The first round of discussion is regarding the merit of ADR. I have a couple of questions. Give a specific question to our panelists. First, let's talk about the merits of ADR. Even though Naja introduced, there are very diverse merits: cost, speed, flexibility, enforcement. Let's take one by one. First, let's touch upon the arbitration. What are the most important merits of arbitration and the reason? Steve, please.
Thank you very much. As Byung-Shi actually introduced me, I actually started my career at the American Arbitration Association way back in 1998. So that was when the whole international arbitration wind was blowing. And having been there for 7 years, I saw the pain point of the growth of the international arbitration. So for me to actually talk about merits in front of very seasoned professionals, it doesn't really do justice. Obviously there's speed and there's flexibility and there's cost, but we know in reality that international arbitration at times can be cumbersome and very, very expensive when you get to a certain point. But by and large, the merits of arbitration still exist in a way that there is flexibility to the parties to design the mechanism as they see fit, or at least they try to do that. There's a certain amount of speed if you're in a very popular common law jurisdiction where things take 5-7 years, yes, then ADR is probably the way to go. ADR in a larger sense is, I always see it as a national business. It's a national, almost a national brand. You know, it's a mechanism for up and coming developing countries or jurisdictions to put something forward saying, you know, you are able to actually conduct business and you are able to have a fair trial or fair mechanism that's available to you in case you get into a dispute. So there are numerous facades in ADR. And so when I talk about merits of ADR, I always try to actually show the story behind it, right? So there's a lot of administrative tasks that's involved with ADR. So whether that's law firms, whether that's individual arbitrators, when you take on something like that, there's an enormous amount of preparation that goes behind the scene to make it look shiny and, shall we say, aesthetically, you know, pleasing to the current users, right? So I just wanted to say that there are two sides to both, you know, in anything that you do. There are definite merits to ADR. I would always recommend it, but do it with caution, and then you'll get a much better, to say, result, and hopefully get a higher bar on the Dr. Alexander's, you know, the satisfaction graph.
By the way, Steve, would you elaborate further? How many cases do you have arbitration, mediation, hybrid format including, and then what percentage of it do for the arbitration and mediation? Please show us statistic too.
I'll give you two statistics. One from the KCAB as a whole will do somewhere between 400 to 500 arbitration cases and somewhere between 60 to 100 international arbitration cases. So those are the normal average numbers that we see from KCAB and KCAB International. If I actually go back to my older job of AAA ICDR, AAA will do 500,000 cases and they'll do about 1,000 new cases every year. And that's actually international. So the scales are very different, and this shows the jurisdiction market size differences as well.
Other panelists, please show your cases and also show the percentage of the arbitration mediation hybrid format. That will be helpful for us to understand clearly the landscape of your market. Okay, next, Diana, I'm going to give the same question to you. What's the merit of your of the arbitrations?
Is it working now? Yeah. Thank you very much, Dean Jung, for this very valid question. And indeed, I always relish every opportunity to share our institutional and jurisdictional experience. And just like my colleague mentioned, before I move to providing my input, I'd like to give a very, very brief introduction to TIAC as an institution, give some statistics as well as Uzbekistan as a jurisdiction. And in that context, in the opinion of many experts, Uzbekistan has recently, in recent years, made significant strides to put itself on the global map of international arbitration as an arbitration-friendly jurisdiction. There's a plethora of reforms that the government is pursuing, but I'd like to focus very briefly on those that are related to arbitration. In 2021, the government has adopted the new law on international commercial arbitration, and the UNCITRAL has officially recognized Uzbekistan as a model law jurisdiction because its 2021 law is literally the verbatim copy of the UNCITRAL's 2006 model law with very few minor additions. As was mentioned earlier, the Asian Development Bank has been and remains the key development partner to support the government efforts in its in its pursuit to reform the arbitration landscape in Uzbekistan. And in addition to the new law, the president of Uzbekistan has initiated the launch of TIAC in 2019. And 6 years down the line, with the active support again from the Asian Development Bank and the Office of General Counsel. As of January 2025, the TIAC's caseload has tripled as opposed to January 2024, which we think is a testament to the growing confidence and trust that the user community and legal community and businesses have in arbitration, and naturally TIAC also as an institution administering those disputes. TIAC is administering both domestic and international disputes, with international cases comprising the majority. And again, statistically speaking, and don't be too harsh with us, because we're probably one of the youngest institutions that represented today. But in 2024, we've had 43 cases with international element. But most importantly, 25% of all cases involved non-Uzbek parties on both sides. Just to give you an example, in the latest case registered with TIAC, the claimant was from Korea and the respondent was from Kazakhstan. So neither party was from Uzbekistan. TIAC has significantly, with its modern case management system and online dispute resolution platform, reduced dispute resolution times. So the median duration is 8 months, compared to other institutions where it normally ranges from 13 to 24 months from the date the request for arbitration is registered. And interestingly, in a little over 30% of the total caseload, the parties have either settled or requested the tribunal to issue the award on agreed terms. So in a little over 30% of all cases, which we think again contributes to the trust the users have towards arbitration as a forum to settle the disputes early and use it as an effective dispute avoidance mechanism, so to say. And last but not least, in 2024, TIAC was nominated by Global Arbitration Review for its Best Innovation Best Innovation Award, together with our dear colleagues from the HKIAC. We have developed a very unique collaborative framework that is called TIAC HKIAC Cross-Institutional Rules of Arbitration, and these rules provide for joint administration of cases where TIAC and HKIAC have very clearly defined roles and functions, and we work together collaboratively to administer the disputes. You can learn more about our rules on our website or the website of the HKIAC. So getting back to your question, Dinjong, I think we're probably among the very few jurisdictions in which we really need to compete with our local courts on efficiency front. In Uzbekistan, the court of first instance usually delivers judgment within 2 months. And that compared to the 8 months, the median duration in arbitration, which is 8 months. Obviously, there's a challenge there's a real challenge that we face in maintaining that competitive edge. So in Uzbekistan, we can't really promote arbitration as a faster dispute resolution method. But what really stands out, though, is the quality of the decision making for very technical and complex disputes. And we all know that in arbitration, parties may nominate or jointly select arbitrators that, in their opinion, have the required expertise to resolve their very technical dispute. Indeed, parties in TIAC administered arbitrations, they can choose arbitrators from a pool of stellar practitioners from different parts of the world. And this is what our users have consistently said is a key factor to choose arbitration over court litigation in Uzbekistan. Lastly on that point, in addition to maintaining top-class arbitrators, we have scrutiny of awards, which adds an additional layer of quality control, so to say, to maintain that standard. And parties do appreciate that. That's probably it from my side.
Thank you so much. Okay, let's turn to the mediation side. I'm going to give this question to Lily and Naoki. Lily, what are the most important merits of mediation in addition to your statistic?
Good afternoon, esteemed colleagues and distinguished guests. It's an honor for me to be here today at this conference as a speaker and represent the Arbitration and Mediation Center of Armenia. Our center, the AMCA, was established in 2023 in May. And in 2024, we began receiving cases. And throughout that year, we handled 6 arbitration cases and 5 mediation cases. 2 out of 6 arbitration cases were international in their nature, and we had 1 international mediation case. Remarkably, from January 2025 to this date, basically this year, we have already registered 24 arbitration cases and 1 mediation case. This unprecedented growth is indeed a promising start of the year, and we are very hopeful for higher statistics that we'll be able to share maybe next year. And turning back to your question about the merits of mediation, I would like to highlight, first of all, that mediation is not just a method of dispute resolution, but it's a transformative process that offers numerous benefits beyond the settlement itself. It preserves and improves the relationships. A preservation of relationship is particularly important when the dispute relates to relationships which have continuous nature, such as family disputes, labor disputes, neighbor disputes. The neighbors have to live next door to each other. So mediation has this power of preserving the relationship. It is flexible and it helps the parties to find their customized solutions to their own dispute. It's fully confidential, productive, and cost-effective. Due to these benefits, at AMCA, we have rather a high rate of settlements in mediation. The cases we had at AMCA highlights the effectiveness of mediation. In one of the cases, the mediation process involved 3 parties in a property-related dispute. This dispute lasted for 7 years in Armenian courts and eventually was resolved within 8 hours at AMCA through mediation. And we had also an international case where the parties were residing in different countries, but the flexibility of mediation process and the application of online platform by AMCA helped the parties to reach a settlement agreement in a week. Although there are different benefits of mediation, I believe that one of the most significant merits of mediation is the enhanced control and flexibility it offers to the parties. In other words, there is a greater degree of party control, party autonomy in mediation, and the parties have an equal say in the process. As we know, the parties are free to agree on the mediator, agree on the conduct of mediation procedure, the language, the timelines, the format, to determine the scope of issues to be submitted to mediation, develop their own solutions, solve their dispute holistically or agree on a partial solution, and eventually terminate the mediation at any time. This shows that the parties who negotiate their own settlements and have this freedom in the mediation process have more control over the outcome of their own dispute. And here, the mediation is important because it's not a determination of a party's fault, but rather the parties reach a mutually agreed settlement. Studies have shown, and I agree here with Naja Alexander, that mediation settlements have higher compliance rates and increased satisfaction because the parties are directly involved in creating the terms, thereby feeling a greater sense of ownership and responsibility. In successful mediation, the parties frequently shift from an adversarial mindset to a solution-oriented we against the problem mindset. And even if the parties do not reach a settlement agreement, the process can still allow them to gain a better understanding of the issues at stake and overcome unrealistic expectations. And I would like to conclude by stressing that the party autonomy in mediation ensures the long-term benefit of mediation, not only reaching a settlement agreement, but also increasing the confidence in parties that they have the ability to solve future conflicts.
Thank you so much. Everyone meet the timeline, but I give the harsh task to my staff to raise the blue card. It's really serious signal, right? Okay. then now, okay. What's the merit of the mediation? Please show your statistic too.
Okay, thank you for having me here in ADBI policy dialogue session. Japan Commercial Arbitration Association, which I represent today, is a leading arbitration institution in Japan. JCAA handles both commercial arbitration and commercial mediation cases. First, statistics. For the past 5 years, JCAA received and handled approximately 70 arbitration cases, more than 80% of which were international cases, many of which involving Asian parties, China, Korea, Taiwan, Vietnam. The other major participant is the United States. JCAA also handles mediation, including international mediation, but the numbers are limited. JCAA is not the only ADR institution in Japan, so I wish to share with you the situation in Japan in general. There are other ADR institutions. To introduce some of them, Bar Association ADRs, Construction Dispute Review Board, and Nuclear Damage Claim Dispute Resolution Center, which handles nuclear damage claim dispute arising from 2011 Fukushima nuclear reactor accident disaster. That the procedure is mediation, but more like a non-binding arbitration. Something similar to early neutral evaluation, you can say. More than 30,000 claims have been handled and settled. Yeah, these ADRs, other ADRs in Japan are mainly domestic ADRs, but there have been a few international cases. For example, Nuclear Damage Claim Dispute Resolution Center handles a claim filed by a major US airline carrier against the Tokyo Electric nuclear generator. Okay. Although in terms of number of international ADR cases, Japan is behind of other jurisdictions. I think even compared with the youngest Tashkent, I hate to admit, but it has, I should say, it has a potential, especially in the field of mediation or non-binding type ADRs. Japanese citizens and business enterprises have more affinity with non-binding type dispute resolution methods, such as mediation or non-binding arbitration, compared to the adjudication and arbitration. The fact that court-annexed mediation received substantial number of cases constantly, approximately 30,000 to 40,000 each year, tells the affinity with mediation. So far, the background statistics. Back to the moderator's question. My short comment on the key merit of ADR, because my colleague already touched on it. Naja enumerated various merits of ADRs. To pick up one of them, I wish to stress it can save time and cost. It applies especially for mediation and non-binding type ADRs. As you see, arbitration, I think, still has merit over litigation in international commercial disputes. However, it tends to be formalistic and cumbersome. It tends to be heavy in terms of time and cost. On the other hand, mediation, again, as have been already touched by my colleague, mediation can be condensed and short, getting rid of cumbersome document production, witness examination processes, and also it can give future-oriented consultation discussion between the disputing parties. In one word, it's flexible, and flexibility leads to cost, excuse me, cost time saving, of course, depending on how it is organized and implemented. I think that is the outstanding merit of mediation and non-binding type ADRs. Thank you.
Thank you so much, Naoki. We invited more than 13 government officers from developing countries. They are sitting here. They are keenly listening to your comments. The panelists emphasize not only arbitration, but also mediation, but there is another format, hybrid format. So Jay is expert about that area. Please, Jay, share your idea on the merit of the hybrid format and also show your statistic.
Good afternoon, everyone. My name is Jay Shin from SIC, and it's a pleasure to be here today. So in order to start from the statistics, we don't have 2024 statistics announced yet, but in 2022, we had 357 cases at SIC, and in 2023, the number was 663. Which 93% were international, 614 cases were international. In terms of mediation, SIC does not administer mediation cases itself, but thanks to SIMC, we have SIAC, SIMC protocol, which allows us to have this format where parties can mediate after they enter into arbitration. So we had 40 ARB-MID-ARB, arbitration, mediation, and arbitration cases since 2014 when SIEC and SIMC announced the protocol. To the question, so what are the merits of the hybrid format? I would like to highlight on 4 merits, if the time allows. First is that it's easier to get the opponent to the mediation table, the hybrid format. So as I already mentioned, you start with arbitration and you can enter into mediation while you're arbitrating. And sometimes when you're mediating, when you want to mediate, one party wants to mediate, it's very hard to get the opponent to mediate and bring them to the table. But having ARB-MID-ARB or other hybrid solutions in different institutions, you can start arbitration and move on to mediation, which is related to my second point, that it increases the chances of settlement. Because parties will have better understanding on their case, there is a higher chance of parties willing to settle when they once enter into mediation. The third point I would like to highlight on is that it saves time. So once you enter into mediation, you have to come up with a settlement within 8 weeks. And it allows you to have time efficient dispute resolution, which in ADR, of course, means it'll be cost efficient as well. The last point that I would like to make is that your settlement can be enforceable. So once the parties reach a settlement, the terms of a settlement can be recorded into a consent arbitral agreement by the arbitral tribunal, which will be protected by the New York Convention. So the settlement that you got from mediation will become an enforceable arbitral award. So these 4 points are the points that I would say are beneficial. And just to add one more point is, someone mentioned that mediation can be a friendly solution to continue the business relationship. ARB-MID-ARB or the hybrid solution can provide you with that as well. You can have a business-friendly solution and change it into an enforceable arbitral award. Thank you.
Thank you, Jay. It's very helpful. But you know what? We are living in an internet society. We experienced the online the health service, but there is online dispute resolution functions. Naja already mentioned that there is online platform-based dispute resolution. Actually, Naja participated in the APAC online dispute resolution framework collaborative. She's an expert. Okay, Faye, I want to ask this question to you. Would you explain to your the practice with the numbers, and also what's the criteria for the dispute using online platform-based disputes?
Thank you, Dean Jung.
Let me clarify, I'm Deputy Dean.
My name is Lu Fei. I'm from CTAC China. A great pleasure to be here. So I'm requested to quote the data first to show the landscape of China ADR development. My organization was established in 1956. So next year we're going to celebrate our 70 years anniversary. We are the oldest arbitration institution in China, yet we're not the only one. From back to 30 years ago when China arbitration law was promulgated, many arbitration institutions have been established in the past 30 years, like 280 already. But still, I think CTAC remains the most influential one, if I may say so, especially in terms of the big large amount disputes, international disputes. Last year, that's 2024, our caseload reached 2013. 758 of them actually are international. But having said that, I have to point out that even some of the domestics actually have, I would say, foreign elements, because a lot of like FIEs are regarded as a Chinese entity, so their disputes are regarded as domestic disputes. So if we take them into consideration, so probably we will have like 2,000 to 3,000 arbitration cases with these foreign elements. The amount of dispute of 2024 actually reached 189 billion Chinese yuan. That's around 30 billion US dollars, taking like 1/7 of all the dispute amount received by Chinese arbitration institutions nationwide, covering like 93 jurisdictions. That's primarily how the ADR is developed, taking CTAC as an example. So I would say that we have seen a steady growth momentum for the past decade. I was very impressed by Dr. Alexander's presentation, quoting data. So I would also like to echo Dr. Alexander by showing a survey made by the Chinese scholars. Back in early 2000, the statistics show that for Chinese enterprises going abroad to invest or trade, 90 of them do not have an arbitration clause or ADR clause in their contract. However, a new survey in 2022 actually shows that 70% of those enterprises actually have already had ADR clause in their contract. That shows the growth of ADR, or the awareness of ADR has been increased among those enterprises. And what noteworthy is 45 of those enterprises think that they're actually satisfactory with those proceedings. Those proceedings sometimes not in China, they're conducted outside. So half of them actually are satisfactory with the proceedings, and also around 40 of them actually have their cases actually mediated finally. So that shows that mediation, especially the combination or the hybrid format, is very well received among the Chinese enterprises. I think that's in relation with our traditional culture of valuing harmony and hating confrontational proceedings. Then I would also like to point out for CTAC cases each year, 1,000. Especially 2024, 1,538 cases actually have been concluded by mediation, either by a consent award or they just reached a settlement and withdraw their proceeding. So that showcased that it's very successful practice because it's very flexible in proceeding. Well, going back to the moderator's question, the online dispute resolution mechanism, we actually have been using the e-filing as early as 2019. And nowadays, like 1/2 our cases actually are filed online. And also the virtual hearing platform actually were especially developed for arbitration hearings. It's not like some online conference meeting system. It's an intelligent, or we call it the smart hearing platform that specially designed. So we can identify the identities of the participants and also can make sure the data security. So now 1/3 of all the hearings in 2021, that's 1,900 hearings were conducted virtually. Well, that's 1/3 of our hearings. Having said that, I have to point out, even we encourage, we put in our rules, like electronic surveys, a virtual hearing, e-filing actually are encouraged and also in priority. We also allow, or we leave the choice to the parties themselves. Such application of those technology will only be made based on the parties' consent. If one of the parties does not agree, then we will go back to the, I would say, traditional way of doing the proceeding. Because we have to consider, there are some parties, especially in developing countries and in some, remote areas in China, they do not have like fancy facilities and they do not have like high-speed data transmission. So if they want to participate in the proceedings or they have some other considerations maybe, then we will respect their choice. So basically, I would say the online platform using actually shortened our time length of concluding a case. For example, back to 5 years ago, the average length of concluding a case was 190 days on average, but nowadays it's like 150 days. So it increased the efficiency, I would say, greatly.
Thank you. I'm so sorry not to give too much time to you. We have another second round. We talked about the merit of ADR, but as Thomas mentioned in the morning, the main reason we are getting together to have ADR for what? For developing our country, developing our economies. Is it really true whether ADR really contributes to economic developments or regional economic integration? Let's see from the panelists. Okay, let's move to the second round. The regional economic integration, economic development. What's the role of the ADR for that purpose? Let me ask this question, Faye and Naoki first. How would ADR facilitate trade and investment for regional economic integration? Faye, you're the first.
Thank you. Me again.
This time, I will give allocate the 3 minutes only, please, with the time.
Well, first of all, of course, I think my colleague have already pointed out efficiency in handling disputes and also the less confrontational, maintaining business relationship will help them to continue their business and boost their cooperation. And second, what I want to point out is the integration of practices by ADR, especially among different jurisdictions and legal systems, will help, I would say, build the faith of the enterprises, to this dispute resolution mechanism, and give them a sort of stable, anticipatable, or a predictable, environment for them to conduct a business, and thus to, I would say, in turn, to boost the economic growth. That's my short answer.
Very efficient. Thank you. And then Naoki.
Okay. Thank you, Faye. To add to Faye's comment, my introductory comment is that dispute resolution mechanism is an important infrastructure of the international economy, trade, and investment. And the ADRs, including arbitration and mediation, are expected to play vital role side by side with litigation at national courts, and I think probably more important role than court adjudication process does. As you see, the disputing parties usually and understandably wish to avoid having to litigate at court in the opponent's jurisdiction. ADRs can serve viable dispute resolution option or safety net when dispute arises, and thereby contribute to the development of international commerce, trade, and investment. Having adequate and viable dispute resolution infrastructure is an important environment for international trade and investment, thus contributing to regional economic integration. This, I do not repeat what was adequately presented in the opening remarks. Let me add one thing. Recognizing that ADR is the effective, important dispute resolution infrastructure in international trade and investment, the Japanese government came up with various measures recently. It adopted guidelines towards invigoration of international arbitration in May 2024, last year, which is an updated version of 2018 interim government report. Between 2018 and 2024, the government pushed forward a couple of legislative initiatives. One is Amendment to Arbitration Act to reflect UNCITRAL 2006 model law, and two, entering into the Singapore Convention, a Singapore Convention on International Mediation by adopting implementation laws. These two actions that took place in 2023, 2 years ago. In addition, during 2019 to 24, Ministry of Justice carried out research project aiming at promotion of international arbitration and mediation in Japan, which was entrusted to Japan International Dispute Resolution Center, including a pilot project to operating hearing facilities in Tokyo and Osaka. Okay, ADR is a big potential in the international field, and as I introduced, the government is currently supportive. So that's important. Of supportive of promotion and development of international ADRs.
Okay, let's invite Steve and Lee regarding the contribution by the ADR to economic development of a developing country. From your perspective, please share your insight. How does ADR contribute economic development?
ADR, in terms of economic development, obviously, as I mentioned to you, I always consider it as a national brand. It's a mechanism it's a necessity for any jurisdiction to be able to say, be to foreign investors or foreign companies that want to come into your jurisdiction, open an office and start doing business, and being able for you to actually say, we know that you don't want to go to Korean courts, so here's a viable alternative on that. We know that you don't know the judges, and so there's a storyline that you could actually implement on that. Getting back to the brand, so and this is for not only for myself, but for the friends that are here. True story. 2 years ago, I got a call from a very well-known law firm saying they have a contract that says KCAB International somewhere in there. So do your arbitrators speak English? So now that brought a smile to my face, not because I was happy to hear that question, because it reconfirmed that this is a national brand issue, right? And for many of the lawyers here, you're not equipped for that job, right? I wouldn't trust brand development to Thomas, right? I would actually, give complicated legal issues to Thomas to solve it for me, right? So I always advocated to any up and coming jurisdiction saying your institution's brand if you want to actually develop it, leave it into the hands of the professionals, who are actually professional marketeers and your professional business development people. You'll have a much better chance of succeeding that and not get questions like, do you speak English, right? So that is my somewhat, so it's a practical point of view on economic development using ADR.
Oh, very clear answer. Thank you so much. And then Lily.
Thank you so much. Actually, Steve covered most of my thoughts, but I would add some points. Unfortunately, in many developing countries, the courts are quite slow, expensive, and with extensive caseloads, which leads to delays in dispute resolution. But ADR reduces the time and cost associated with dispute resolution, creating a more predictable and stable business environment. This predictability, of course, encourages both domestic and foreign investments, and predictability not only in terms of like language, but also expertise, the specialization that the arbitrator will have. And I will add the statistics from a survey that showed that promoting arbitration by joining the New York Convention increases foreign direct investments in countries by 77%, and international trade by up to 30%. Similarly, adopting the UNCITRAL model law in international commercial arbitration has led to a 67% increase in FDI flows and a 7% rise in trade. A study by the OECD also found that one of the biggest barriers for small and medium-sized enterprises entering into the international markets is the uncertainty around resolving cross-border disputes. Thus, having clear and reliable ADR mechanisms creates a safer and more attractive environment for investors and businesses, which in turn, of course, contributes to the economic development of the country.
Okay, the key is that how to invite foreign direct investment to develop your country. But if there is a dispute, then there should be something. I'm going to invite Jay to have to share his insight. What are the most important elements in resolving the investor-state disputes?
Thank you. Yes, I worked for the Korean government Ministry of Education for 2 years, and based on my experience, I would like to focus on 3 things that I felt, and now working for SIC. First is 3 things. Yeah, 3 things. First, prevention. Of course, prevention of disputes better than reaction. So I think all government employees should be educated with the basic principles of bilateral international treaties, and understand that it's not only the people who draft those treaties, but also certain government actions, policies, decisions can trigger a dispute in the future. And in order to understand the whole process, they have to understand these main principles of these treaties. The second point I would like to make is document and record keeping. There are a lot of documents in the government, different means of communications, starting from official documents to emails, text messages, and even internal chat messages. And all these can become evidence in disputes if in the future there is a dispute related to it. And lastly, I would like to say choosing a reliable institution and arbitrator, if it's a mediation, which I think rarely would happen if it's an ISD case, but the right institution and arbitrator is, I think, essential. So you want to, of course, do a background check of the arbitrator and make sure what these arbitrators' views are on sensitive points related to your dispute. Thank you.
Thank you, Jay. I thought that lawyers normally are interested in litigation and how to make money using the litigation, but Jay shared that prevention is very important. Very good point. Yes, prevention is very important. We will develop the prevention in the next step. I really want to working for that issue too. And then let me invite to Diana. How can we improve the investor-state disputes?
Well, I think I'd like to share 2 things. and capacity building, definitely, and continual capacity building is definitely key. And I know that the government of Uzbekistan, jointly with the Asian Development Bank, have just organized the training for various stakeholders, including the representatives of the Ministry of Justice, Ministry of Investments, and other relevant ministries. And interestingly, I remember vividly the discussion that I had with one of my colleagues from the Ministry of Investments, and he's not a lawyer, by the way. The discussion was around salinity tests. And I was very surprised to hear that coming from a non-legal practitioner. And I think this is genuinely a testament to the excellent work that the Asian Development Bank is also doing on capacity building front. And I also agree with Jay, there's definitely room for improvement for all of us on dispute avoidance. I know that Peru as a jurisdiction has set up a commission and early defense system that helped them reduce the amount claimed by the investors from 50 billion to literally $1 million. So they've managed with the very effective and efficient dispute avoidance system in place, they've managed to reduce that from 50 billion to 1 million. So that's huge. So we definitely need to learn more about dispute avoidance work. And we at SIAC have a dispute avoidance mandate. And we're currently working with a number of stakeholders to actually set up that mechanism, potentially involving early neutral evaluation system during the cooling off period that is usually in place, before a formal arbitration proceeding commences.
Okay, thank you so much. Our time is very short, it's running out. By the way, now I open the floor to the audience to take some questions. Okay, there's one person. Okay, and there is another question online. Okay, let me invite you first. Please show your name and all your profession.
Thank you very much, and thank you very much for the invitation on this forum. My name is Guru. I'm Director for Legal and Economic Studies of Indonesia Ministry of Foreign Affairs. Thank you very much for the presentation and also discussion. We see that in the perspective of the avoidance of proceeding like arbitration, it's also interests us to have a further having mediation in practice, especially in developing Indonesia treaty, especially the investment treaty. But there are two questions maybe that may be beneficial to think of in order to see how the mediation is be effective, especially on the two issues that presented by the panelists. There is cost and time effectiveness. The first one may be, what are primary cost drivers in mediation and how do they compare to the costs associated with the arbitration? Because as the present panelists mentioned, the development of the mediation especially happen because we trying to avoid the costly arbitration and also litigation. So in that case, what are the drivers, primary cost drivers in mediation? And the second question is, have you seen in the experiences that you have cases where parties opted for mediation but still ended up in the arbitration? What lesson that could be learned from the situation? And the third one, because the last two panelists mentioned about the ISDS, it's come into my mind whether there are there could be like institutional mediation and ad hoc mediation. Which one better in that case, especially in handling cases like ISDS? Thank you very much for the opportunity.
Thank you so much. Indeed, there is a benefit to have government officers to share their real important the matters at this moment. Thank you so much. He has 3 questions. He wanted the merit of the mediation in terms of cost. That's the first questions. Who want to answer to this question first? Shortly.
Yeah, so I'll be quick. Our survey doesn't have any data on this, and I have some data in my head that's come out of the UK, in fact. But essentially, your costs are the mediator, the lawyers, the venue, travel, right? And the and the discrepancy or the difference between what international mediation, international commercial arbitration are dramatic. If you're interested, I can find those statistics and send them to you. It also has a number of days. I mean, if you think with preparation and days, it might take you a number of weeks compared to, let's just say, a year. I mean, the costs are evident.
Also, you may answer to this question because you cover everything. There is a mediation and the end up is the arbitration. What's the cause of this one? Yeah.
Yes. Yeah, I get asked this one a lot. Look, most mediations settle, and there is high compliance, as we've also heard from experience. There's high compliance with mediated outcomes, right? So it's only a few cases where there's not. Even where it doesn't settle, anecdotal evidence tells us there's very often a settlement a couple of weeks later, with or without the mediator, right? And even if not, you've typically isolated the issues in the dispute. The preparation you've done, you would have had to do for arbitration anyway. The arbitration is typically shorter because there are fewer issues, usually, that you would then be arbitrating, right? So it's not a sort of wasted effort in that sense, if that's helpful. Most of that's based on anecdotal evidence, not statistics, though.
Okay, by the way, regarding the third question, I want to suggest deferring this question to the next 6 sessions because we are really delving into that issues, mediation, institutionalized mediation, and also ADR mediation in the context of investor state disputes, please, okay? Then let me read it loudly to the questions raised by the audience outside. Actually, more than 400 people registered. It's also broadcast lively, so don't sleep. You are monitored. Okay, let me loud it. Do you believe mass arbitration is an effective method for resolving large-scale dispute? And what are the key challenges and benefits for arbitration and arbitration institutions when handling large volume of claims in this context? Mass arbitration. I'm not familiar with this, the concept and practice. Who wanna answer to these questions? Okay, Jay.
Quick, there are many means of flexibility arbitration can provide. And today we talk arbitration as if it is not that time efficient, but I think we might be misleading the audience that arbitration can actually be very time efficient. There are like expedited procedures, not only at SIC, but other institutions as well. Streamlined procedure we have now, which can come up with an award within 3 months since the constitution of the arbitral tribunal. And we also have consolidated procedures and other ways to manage these mass disputes more effectively, introduced in our new rules. So I would say arbitration compared to litigation and maybe other means of dispute resolution can be a very attractive way of solving your disputes.
Okay, actually, I'm sorry, there is another questions. Let me digest this, the remaining questions. Don't you think we should have an Asia-specific model and forum to resolve the business dispute between Asian countries? As a tailored to Asia-Pacific region, the questioner asking about that approach. Would you share some idea? Okay,
Well,
Faye.
since the microphone has been passed to me, actually, I was intended to answer the previous question, but
Answer the previous question and then follow.
well, yeah, Jay mentioned about the consolidation. Actually, to my understanding, the mass arbitration can refer to like multi-contracts disputes at the initiation of arbitration, and also consolidation afterwards, and also joiners and the joint additional contracts. So there are a lot of mechanisms can ensure that different kind of disputes can be combined into one proceeding so as to be resolved, I would say, at once. Yeah, and for this question, well, it would be very ideal, of course, if we could have a forum that will resolve the Asia-specific disputes, because I think Asia is a special geographical region that has some common cultural elements. If it can be done, of course, it's very ideal. If not, I think most of the institutions are doing integration of arbitration practice, so that different cultural, I mean, especially eco cultures, can be coordinated and integrated into the practice so as to make the stakeholders feel comfortable in the proceedings and make them have more faith in the arbitration mechanism.
Let me add my answer to this question. Actually, this is one of the topics we are going to develop. We are living in Asia Pacific countries. We are familiar with our cultures. There are common law approach and civil law approach, but there's a different. In case of China, they have a civil law system, and Japan also Korea. So, but by the way, arbitration is has been developed according to a common law. So in that sense, there must be some development to tailor this existing system to accommodate our existing requests or demands. That's the very new area, but it's very ambitious, but things to be done. So in that sense, ADBI, ADB will work together to develop this some kind of a tailored approach to meet the demands from the citizens living in civil law countries. That's the correct answer to these questions. Okay, then we have a final question because we have only 2 minutes. Okay, please.
Thank you. My name is Sopan from the Ministry of Justice of Cambodia. My question is going to Lilith from Armenia. You mentioned about the adoption of your mediation law last year, 2023. And my question is, how long does it take for you to adopt the mediation law? And how do you work with judicial bodies? Thank you.
Thank you so much for your question. Actually, our mediation law was adopted in 2015, not in, yeah, it was long ago. But the AMCA was established in 2023. And in 2024, we adopted our mediation rules. This is actually the mediation law was adopted in 2018 in Armenia, but starting from 2015, we already had the mediation institution, but the Ministry of Justice representatives will delve into it during the following session. But nowadays, as an institution, we work with the courts to develop the mediation institution, because the courts have the ability to appoint mediation, and the court annex mediations sometimes can be quite successful. And what we do as an institution, we offer the help to the mediators who are appointed by the court, and we assist them with organizing the mediation, and they apply our rules. And this is how AMCA works with the courts to handle mediation.
Okay. Thank you so much. We meet the timeline. I'm very happy to see audience engaged in this discussion. It's really a great achievement. I didn't expect the active participation from audience. Therefore, I prepared the third question, but I needed to skip that questions. Thank you so much. But in the meanwhile, please make this opportunity to set up the network for further the learning. In case of the government officer, please use this opportunity and have some advice and insight to bring to your country to develop your legal system. That's really important. And also practitioner, please set up the good network with the government officer. This is really the function of this ADBI, ADB co-hosting events. That's the benefit for in-person meeting. Please enjoy this opportunity. Thank you so much for your attention. Thank you. Thank you.
Now we will begin the session to dealing with the common challenges global society face in international ADR field. And I'm very happy to invite Mr. Tezuka Hiroyuki as a moderator. Mr. Tezuka is partner of Nishimura Asai Law Firm, and he's taking a very important roles in Japanese ADR field, including the chair of the JCAA Advisory Board and the chief director of JIMC. The floor is yours.
Thank you very much. Good afternoon, everyone. And it's my great honor to serve as a moderator for this session 2 of day 1 with such a distinguished group of panelists, 2 of whom are joining online. The concept of the session 2 is common challenges global society faces in international ADR. ADR in this context includes both arbitration and mediation. We have heard very interesting and stimulating discussions, including helpful statistics about the development and progress of ADR in various jurisdictions in this morning. But in this session, we are somehow looking back and try to see what are the challenges, if any, we are facing in terms of the promotion of ADR, what could be the factors that affect the increase of the use of ADR or the user satisfaction. It may be cultural or perceptional things, or the undeveloped legal framework, insufficient education, etc. But not only trying to locate the challenges and possible problems, would like to hear from our distinguished speakers as to what kind of efforts to overcome such challenges have been taken. So let me briefly introduce our panelists. I think we have master slides where there is a picture, but maybe without the help of that slides, let me just briefly, I'll introduce our panelists. First, Rema Bandari Chatterjee, joining online from India. She's a very experienced mediation lawyer, and I thank Rema to participate online. And the more detailed CV is on the materials. So in the interest of time, let me be very, very brief. And second, on this slide, Mr. Watterson Netta, joining virtually from Fiji. He is also a very significant figure in the Fijian legal society, and particularly in the field of ADR. And on this slide, far right, and second from your right, in-person attendance, thank you very much. Coming all the way from Melbourne, Ms. Anne Sutherland, who is another mediation specialist and also teaches in the various educational institutions. And then the next slide, please. Yeah, we have Yunjae Beck, or probably better known as YJ in the arbitration community, who is a very experienced arbitration counsel, arbitrator, and also have a wide variety of experiences in mediation coming from Seoul. And last but not the least, to my left, Professor Mr. Kim from the Keio University. And she is a very well-known professor in the field of dispute resolution, particularly the ADR arbitration. So thank you for joining us while she is very busy with her teaching and other commitments. So without further ado, let me raise the issues or topics. Can I have the next slide? Yes, I have 3 topics for this session. And topic 1, I have 2 questions. How can ADR be made more accessible to its users in general, but in particular, small and medium enterprises, as well as individuals in the B2C disputes in developing regions. In B2C disputes, I mean that there are lots of ADR, particularly mediation cases for family disputes. And because of the time limit, I try to somehow, exclude that individual to individual disputes. That is why I say in B2C disputes here. And the second question for topic 1 is, what are the barriers to achieving this, and how can such barriers be overcome in a global context? So let me first ask Anne to start with her a kind of opening presentation for this topic 1. Thank you, Anna.
Thank you. Now we're online. Thank you, Hiroyuki. I would like to start by answering this question. It's already in 2 parts, and then I'm going to have 2 layers to answering the 2 parts together in a way. I think when we think about, I actually think that the barriers that people say to the increased use of ADR, the most often cited, it's in our materials, in our program, things like culture, language. I don't think they're the big barriers. I think the main barrier is familiarity with the process. Because in my experience, I'd be interested in what everyone else thinks. In my experience, once people experience a mediation, and I'll speak more particularly, my experience is as a mediator. I have also arbitrated, but my main practice is as a mediator. Once people experience it directly, they like it. That's what I find. So I think we need to go a layer up with the question of how does, if you look at the overarching theme of our gathering here for 2 days, how do we disseminate the use of ADR in developing economies in our region? I think there are 5 key ways I've noticed, in looking at Australia as an example. We happen to have quite a mature market in mediation and ADR. And so I turned my mind to, how did that come about? And if we could have the next slide now. That's the one. Thank you. I noticed that there are multiple forces working at once, and each force works on the other. So this is very connected to what Nadia Alexander was saying about if we want to get people on that highway, how do they get to the highway? And I noticed in Australia, we had, for example, and it was way back when I was a baby lawyer in the early 90s. It was 1992. I was an article clerk at a big commercial firm, and there was an event at our Supreme Court called Settlement Week. And it was all about this crazy new idea of mediation. And a bunch of barristers and practitioners convinced the court to let them have a go at mediating a bunch of cases. So let's see what happens, because the legal profession, the judiciary, they were all naturally skeptical, and it was unfamiliar to them. And that was a turning point in the Australian history of adopting ADR, that over 1 week, they settled such a high proportion of the matters. The legal profession saw, my goodness, this works, and this can fix our long court lists. And so I very much think that that's why the legal profession is in this circle, because while we can spend a lot of time talking to the public or businesses about mediation, it is, in my experience, it is the legal advisors who are the gatekeepers. If the lawyers don't advise mediation, the client will not do it. So getting the lawyers on board is critical, and getting the judiciary on board is critical, because have you noticed that lawyers listen to judges? So if judges think it's a good idea, the lawyers will consider it. And then the legislation piece in our environment was actually a very significant piece of legislation called the Civil Procedure Act that was passed in 2010. And it wasn't seeking to regulate mediation. It was drawing the legal profession's attention to mediation and settlement procedures. So it was increasing the duties on lawyers to be looking for settlement opportunities and using ADR when it served their clients' interests. This was a very significant development and a very interesting idea, I think, for developing economies and situations where we're trying to get uptake of something that is going to at first seem foreign. And of course, none of these things happen overnight, but they are all very powerful and they all influence each other. And then it was later, as the idea and practice of mediation took off, that you then have people training people in how to do it properly. You then have our profession developing its own professional standards, which regulate what is and isn't a mediation, how people have to practice it, the professional standards they have to adhere to. So these 5 things in unison, and it actually doesn't matter, I don't think, which comes first. That will be an historical particularity of the place. In our case, there was this event of Settlement Week, which kick-started a lot of things. But it could be a different event in a different place, or you could, if you have a sympathetic judge, if you have some highly respected judiciary who get on board, they can become a force for bringing the rest of the judiciary along and influencing the legal profession. It doesn't matter where the circle starts, but all these things need to start happening for the marketplace to actually start using ADR. And listening this morning to the last panel, I think I might have to add another square to this circle, which is ADR clauses in contracts. So as Nadia pointed out, a big reason why people use it is often just because they have to. They are mandated to by their own contract. So that's another force in the mix. And then I think it's when all of these things start to operate, you then have the opportunity for people to use ADR then it's the next level question, how do we make it more accessible? And if I could put the next slide up now, this one, you know, will be more variable in every place that we go. But in addition to the training and professional standards, which have to be kept up constantly, I think. So by professional standards, I mean, there are actually rules about how mediators have to conduct themselves. And we have a wonderful example to answer both our questions if by simply looking to arbitration. Arbitration has done it before us. If we look at, you know, the history of arbitration since the New York Convention in 1958, all the things that, you know, have, the whole landscape has changed dramatically. And so when you're trying to make it more accessible, it's things like having diversity in the profession. It's things like having enough flexibility to be culturally specific. It's things like government and industry funding panels of practitioners. So, for example, in my country, in Victoria, the government has set up a commission called the Small Business Commission. So thinking about our question of SMEs, small and medium-sized enterprises particularly, that's a government-sponsored service to small businesses for a very affordable cost they can access mediation. So as I say, we could talk forever about how do you make it accessible, and there'll be lots of factors. So these are just some ideas, by no means the whole answer.
Thank you very much. Maybe I should turn to YJ from the civil law jurisdiction, and he is very active, not only as an arbitrator, but also as an counsel. So I would like to know particularly whether he has been a kind of gatekeeper for the use of ADR, or it is his client's issue, or if he has any other challenges he can find in Korea.
Thank you. Thank you. Yeah, I basically agree with Anne's suggestions. I think we have to provide a wonderful platform for the ADR, but this time I would like to urge you to change your perspective. Now we are talking about provider side. We gonna provide this kind of things to our users, but we never ask our users, what do you need from us? So small and medium-sized enterprise, they have reason why they do not use ADR, because they have no intention to spend a lot of money for the ADR. So just an answer mentioned, if we have a kind of government supporting bodies which can provide ADR services for small and medium-sized enterprise or individuals, then probably there will be more possibility for ADR users opportunity. And another thing is that you may not believe that when I was young, in my generation, I was considered as one of the Korean lawyer who speaks quite well English. But these days, no one believes that. In Korea, there are so many young, talented lawyers who speaks almost native English. So I think language is no barrier at all. And also common law or civil law difference, I don't think that's a barrier, because every institution has panel of the arbitrators or mediators list comprising of from civil law countries or common law countries. So legal difference is not a barrier at all. The only barrier is, I think, the cost. So if we go to small and medium-sized company and ask them, hey, this is only $1 million dispute. So if you take ADR, then probably you can solve your dispute very reasonable cost and very quickly. But let's look at the real life. Is it true? I had a very bad experience. I have a very big Korean company came to me and asked me to handle one arbitration case. the value of dispute was only $1 million. So I told them, do not do arbitration. Please go to your client and enter into settlement. But because of the business tensions, they did not settle the case, and finally they entered into arbitration. It took almost 2 years, and legal fee was almost 1.8 million US dollars. So they won the case, but they came to me and blamed me. Hey, YJ, we only got $1 million, but we spent $1.7 million to you. So I told them, I told you not to do arbitration. So to provide more opportunity to small and medium-sized enterprise or individuals, I think government or international body support is quite necessary. Thank you.
Thank you very much. Raymond, do you have anything to add? I think that India is known to be a jurisdiction where court litigation may take very, very long time. And I would guess that people find some nice aspect of the speediness of ADR. But having said that, you find any obstacles in promotion of or accessibility of ADR in India?
Well, first of all, good morning to everyone from India. It's a morning. And thank you, Tezuka, for the wonderful introduction. And actually, I totally agree with Anne that the role of legal professionals, lawyers, and judges and our legislation is indispensable. And agree totally with YJ that the cost is actually a very, very important barrier in the role of ADR. Well, the question specifically, if with regard to the India, I would like to say definitely the court litigation, like any other country, it takes more time. And that is why we are working towards promoting ADR in our country greatly. And specifically to MSME, I would like to say that we have a specific MSME Act, which there is a council which particularly handles the delays in payment from between the buyers and the suppliers. And to handle this, there are provisions like within 45 days the payment has to be made. There is a provision by which you can impose interest if there is a delay payment. And definitely the most important provision here is that it is mandatory to go for mediation and conciliation before they go for the arbitration. And specifically, our new Mediation Act, it also specifically says that mediation has to be completed within a particular time frame of 120 days. So our mediation and ADR system is actually working very close to cut this cost barrier and to give time relief to the people. So there are online portals where the complaints can be filed directly, and so that people can monitor the fast track of the cases with these councils. Secondly, with regard to the arbitration, we all know that we have an Arbitration and Conciliation Act, which is based on UNCITRAL model of law. So there are recently rules framed by IIAC, that is Indian International Arbitration Rule 2024, specifically with regard to MSMEs, which they provide that there should be no filing fees, the less fee for the arbitrators, less fee for the administration, fast track procedure, and in case they cannot afford, the legal aid is also provided to them. So that way we are, and more so I would like to say that we have mediation centers which are court annexed, which are providing mediation free of cost to all the litigants and the disputants if the matter is annexed with the court. So in India, to save time and money, specifically with regard to MSMEs, we have an act, and we have with regard to the B2C businesses, which is another, I think, important part of our question. So for B2C, I would like to say that there is a Consumer Protection Act, under which we are having different district forums at district level, state level, national level of our country, and which are a little informal, and there is no need to have a specifically the lawyers. This procedure is more simple, and again there are mediation centers annexed with them, free of cost, providing mediation to all the litigants. So that way, I think India is actually moving forward in a very big way and the ADR is coming to the doorsteps of the litigants. Over to you. I think I've
Thank you
answered the
very
question
much.
from legal perspective, from Indian perspective.
Can I now ask Watson to add something from the viewpoint of Fiji? You have been working very extensively and closely with the government, and you may have some good points. Watson,
Thank you. Thank you. I hope you guys can hear me. Good evening from Fiji. I think we're 3 hours ahead, so I've been waiting for my lunch hour for your guys' lunch hour to finish, but I'm glad we're on to our session now. I'm going to have to agree with Anne. I mean, biggest barrier in Fiji, I hate to be as blunt, but it's actually the buy-in of the legal practitioners in Fiji. Most of them feel threatened in terms of mediation because of the fact, I mean, there's a lot of work that needs to be done in that area, and this probably ties in with the third question of our session, which is a lot of awareness, and just sensitizing lawyers and legal practitioners that mediation and arbitration are other forms and of dispute settlement that they should be considering and advising their clients. And just like Rima said, legal practitioners lawyers are the gatekeepers. So clients will only go to lawyers and listen to what their lawyers advise them. So I've taken a proactive approach. I've started my own mediation consultancy called Mediation Pacific. And we've done, in the last 2 years, I provided training called the Mediator's Perspective. So I go around sharing my experiences in being a mediator, previous mediator with the Ministry of Employment, and also current mediator with the Fiji Mediation Center. And we've gotten it attached to the Board of Legal Education to give it 5 CLE points, which is obviously all the lawyers cramble for before the renewal of their practicing certificate. So we've got a roll of around 1,000, I think close to 1,200 legal practitioners at the moment. And over the last 2 years, we've kind of sensitized them through that training. We've done around 120 legal practitioners. So it's a bit of a, push and shove and, bits and pieces of the puzzle being put together, both on the bottom up and a top down approach as well. So, and there's a very strong point in terms of legal practitioners being gatekeepers in the fact that we need to persuade them more to go the way the world is going in terms of making ADR the more appropriate form of dispute resolution rather than being an alternative. So I'm completely hands-on with that. With regard to accessibility to MSMEs, we don't have a specific MSME Act like you guys have in India. There has been push by the Ministry of Trade. Our new government has included a portfolio for MSMEs with the Minister of Trade. So this is the first time we've actually had a ministry for MSMEs. So, and I actually chair, in one of my other hats is as the chairman of the MSME Council under the Fiji Commerce Employees Federation, which is the private sector body representing MSMEs. So I do a lot of advocacy in the MSME space, and all of what we're doing is accessibility of these services to MSMEs. But we don't have anything particular per se for the Fiji Mediation Center. We have provision in the rules in terms of accessibility to those that cannot afford the fees and charges. They write in a letter and they give a bit of evidence, and then it goes by, we have to address it to the chief registrar to state that they cannot afford, and it's assessed on a case-by-case basis. And then, of course, the center waives the fee. And I've done a few pro bono cases with the Fiji Mediation Center because of that. Other than that, in terms of accessibility, I would like to see that it is added on to the services that are currently provided by our legal aid commission, because those guys, they can be a bit overwhelmed with the current cases that they have, but provided that this is added on, then we've got to give it a bit more funding from government to facilitate the accessibility to MSMEs. Apart from that, consumer complaints are usually more consumer focused in terms of household consumers, I mean, from B to C. We have the Consumer Council of Fiji and also the Fiji Commerce Commission that looks into complaints raised by household consumers against traders. And they both utilize the mediation process as well as the first attempt at trying to resolve consumer complaints. We also have the Small Claims Tribunal. That's more of a refereeing kind of approach. And then, of course, slightly focused more on arbitration in terms of resolving consumer complaints in that sense. Way of background, with the 2 international conventions, Fiji has, I think we were one of, if not the first countries to ratify the Singapore Convention. Yes, I think that was in 2019. We've signed, we've ratified, but we're yet to domesticate local legislation to reflect it. The Fiji Mediation Center was set up in 2016 to look into resolving the backlog of civil cases within the Fiji court system. And this center will most probably have an international once we incorporate a local legislation. Fiji has also signed on and ratified the New York Convention on Arbitration and domesticated an International Arbitration Act 2017. So that's a bit of background I thought I'd add on to our discussions today, given that we're discussing ADR on an international plane. But I have to agree with Anne. We've got to devise more ways to get the buy-in of the lawyers. I mean, I've had continuous discussions with George Lim from the Singapore Mediation Center. He's been very helpful with the setup of the center. And of course, he's been very friendly with Fiji, and we've developed a good working relationship over the years. We're trying to bring him back over for training this year so that we can also, again, sensitize the judiciary and also get some lawyers accredited as well so they can, of course, bring their cases more to the center. And just get everybody working together at the same time. And I completely agree with Anne's whole flow chart of, all the different elements working together, top down, bottom up. I'm trying my best to do stuff bottom up and keeping the mediation flame burning here. But yeah, I think that's pretty much from me in terms of accessibility to MSMEs and also what are the barriers there? From Fiji's perspective, I think, the lawyers buy-in, legal practitioners buy-in being foremost of that one. Thank you.
Yeah, thank you very much. And then can I ask Misa to follow up briefly from the perspective of Japan?
I believe my co-working panelists already have covered most of the issues. So I just would like to briefly mention the one thing is about the from the perspective of provider, which is the online dispute resolution is from many researchers, it is insisted quite useful, especially for the individuals who has a small claims, and because usual mediation schemes are quite time consuming and also it's costly. Having an effective online dispute resolution system may be a quite effective way. And for this, from the user perspective, even in Japan, in these developed countries, one of the current Japanese surveys shows that there are some small and medium enterprises which simply don't pay much attention to dispute resolution system. So I think to go to mediation or to go to arbitration, we have to have an agreement, and that agreement have to be in a contract. So when forming a contract, to insert those kind of agreement clauses quite essential, is a key point. And recently, Japanese government is working to promote and there are like model clauses for the contract, a model contract they offer to insist one of these agreement clauses, ADR agreement clauses, and I think it's quite effective. Thank you.
Thank you very much. And then moving to the next topic, topic 2. Can I have the slide here? Yes. How can impartiality be ensured in the ADR process, particularly in multi-jurisdictional disputes? That is a simple question, but maybe it's a little bit complicated issue. And may I ask YJ to briefly open up the discussions?
I'm always talking from minorist perspective. Some developing countries, they often express concerns over the impartiality of ADR process. Why? Because there is a lack of diversity in ADR tribunal members, and also most tribal members came from the Western world, Commonwealth countries. So developing countries have developing countries has some worries about the impartiality of the tribal members and how we can overcome those impartiality. There are so many causes, like for example, IBA's guidelines on conflict of interest, and also UNCITRAL has similar guidelines, note on organizing arbitral proceedings, and ICSID has similar rules. But these rules have only covers the conflict of interest issues. But I would like to raise another issue, the personal acquaintance and personal connection. Those guidelines cover that issue? I don't think so. I worked as an arbitration lawyer for more than 35 years, and a couple of years ago, I had a very bad experience. I worked for one construction company doing construction work in Saudi Arabia, and they raised arbitration against the big Saudi Arabian government agency, and the Saudi Arabian government appointed very wonderful international law firms led by very influencing arbitration lawyer. So during our whole arbitration proceedings, our tribal members, I have some fears that our tribal members have a little bit favorable to those international law firms than our side. Think about this happens in developing countries, then probably developing countries will lose their confidence in ADR process. So I think now we have to find out how we can ensure the impartiality of the ADR process. Probably the answer will be we have to diversify our tribal members, and also we have to ensure the transparency of appointment process. And also we have to take some thorough education and scrutiny for our tribal members. Otherwise, the impartiality will not be guaranteed.
Thank
Sorry
you
to
very
say
much.
that.
Yeah, thank you very much. So May I ask Anne to follow up if you have anything to add?
Thank you, certainly. It's absolutely vital for the dissemination of ADR that the consumers have confidence in the impartiality of the people conducting the processes. That's beyond question. So how do we achieve that? I think, and it's interesting to hear about your experiences, YJ, and concerning. We have a number of mechanisms. One is, having a number of arbitrators on the panel. Similarly, in mediation, we can have co-mediation. In both instances, there is the opportunity for the parties to have an influence on the choice of the arbitrators or on the choice of the mediators. We would be hoping this would help. Absolutely, we need more diversity in the profession so that all the users can see themselves represented in the people conducting the processes. I also think it's important, and of course this links, I'll try not to constantly go back to my circle, but it does link again with the fact that when you have professional standards, then you have a yardstick to measure and to control behavior to some extent and to make clear what we mean by impartiality. I also think it's very important, though, to distinguish between arbitration and mediation on this question. And the main reason is because mediation is not a determinative process. So it should be less concerning, you would think, in the mediation context than in the arbitration context, because the mediator is not a decision maker. They cannot impose an outcome on the parties. So it's a really significant thing to remember in terms of us thinking about how do we disseminate the use, how do we advocate for the use of ADR and mediation and increase people's confidence in it, is that that is a risk minimization point. Every government wants to minimize risk. Every corporation wants to minimize risk. And if the use of mediation is actually a very low risk process choice, because the mediator has no power over you. If you do not have confidence in their impartiality, you do not have to be bound by what they say. And that in itself creates a market force upon the mediators to demonstrate their impartiality in order to have the confidence of their clients and in order to get more work. So they would be my main ideas.
Thank you very much. May I now ask Misa to briefly comment if you have?
Yes. YJ has mentioned the perspective of developing countries, and I would like to add, I know the time is running out, but one arbitration case of Japanese Supreme Court decision, which is about, so in that case, JCAA's arbitral award was attacked to set aside on the ground of lack of impartiality. And in that case, one arbitrator was a partner lawyer of one of the biggest law firms, and he was working in a Singapore office. Later, and at some point when the arbitration proceeding was still going on, a lawyer joined in San Francisco of the same law firm, and he was representing the US class action lawsuit of an affiliate company of one of the arbitration parties. So the arbitrator did not disclose the fact to the parties, and that was the reason why the attacking party wanted to set aside the award. And I think this case is illustrative in many ways. Here, I would like to focus on 3 points. First is that even though the case seems to be quite a familiar example in a global arbitration where a big law firm is involved, it was not clear whether this case fit in red, orange, or green list according to IBA guidelines. So IBA guidelines is not perfect, and we still need some more clarification. Second point is that the case shows us the possibility that the impartiality rules might be misused by losing party in order to set aside the award, via through creating the conflicts of interest among the arbitrator and the parties. Imagine if the party asks a lawyer with whom he has a connection to move the firm where the arbitrator belongs, so they can create the conflicts of interest quite easily. The third point is that the case provokes an argument where whether the impartiality issue shall be discussed equally in challenge process as well as in setting aside process. I believe that impartiality shall be scrutinized severely before and during the arbitration. However, the same severe standard might ruin the stability of the arbitral awards. So that's what I.
Thank you very much. And I think there are 2 distinct but related issues, that is existence of conflict or the appearance and the disclosure of the potential conflict. But in the interest of time, may I ask the speakers who are online if you have any brief comments before we move on to the last and the third topic.
So I would just like to add one of the experience to maintain impartiality. As impartiality, I would say it is not just a procedural thing, but it has to be seen with the body language and the way a mediator is conducting the process. It is not that you can't say that just I am impartial. It has to be portrayed by various actions of a mediator or an arbitrator. So I will just share one of the experiences when I was conducting a mediation. While in the first session, while I was giving an opening statement to the parties, I just remember, having this thing that I have seen one of the parties somewhere, but I was not able to recall when, where, and in what context. So I think a mediator has to be honest from, the core of the heart. So I very honestly just asked them that, ma'am, I have seen you somewhere, but I'm not able to remember. Can you please tell me if you can remember? So she started smiling and she said, yes, ma'am, few years back, I came to you to take legal opinion on this particular case. So then I asked the other side whether you still want me to be a mediator in your case or not. And I would say that the person said that, yes, ma'am, rather I trust you more because you are very openly disclosing the reason that why you should not be a mediator. Rather, I do not want any other mediator apart from you in the case. So, there is no set formula that to, establish impartiality in the process, but and with the experience, I think we keep on adding more and more things. The ultimate aim is basically that people should have trust in the process of mediation, and I would say the mediator and arbitrator both are equally responsible to establish this impartiality, neutrality in the mediation process by disclosing conflict of interest, by giving them equal opportunity and providing a balanced, I think, atmosphere where they all can equally participate. I just wanted to add this to the discussion. Thank you.
Thank you very much. Now we move on to the last topic, topic 3. How can international ADR bodies create training and awareness programs to promote ADR adoption in countries with limited experience? And then what role do local legal frameworks and national policies play in either enabling or hindering the growth of ADR? So can I ask Rima to briefly touch upon those 2 topics, if you can?
Thank you. Actually, it's a very good question. And on this, I would like to say that already various organizations like UNCITRAL and ICSID, they have historically worked with various national, governments to provide technical support and capacity building programs for growth of ADR. Well, these programs are often include, they often include training by international ADR experts to the local legal professionals, community leaders, who in turn becomes, I would say, the brand ambassadors or the regional advocates, and adopt ADR methods to local norms and ensure that ADR process resonate with the cultural expectations of that particular region. Well, in the other ways is that we can include training by international ADR experts. And the second is there can be a public-private partnership where these international ADR bodies, they partner with the law firms, universities, NGOs to train mediators, to establish mediation centers, and I would say promote standardized accreditation of mediators as well as arbitrators to keep, the level of the process on a very high pedestal. So, and thirdly, we can work towards adoption of model laws, by helping nations, developing nations, particularly if they are not equipped with those laws, by helping them, for example, UNCITRAL model law on international commercial arbitration. It is adopted by us. It is our Arbitration and Conciliation Act is actually based on that. So in Indian context, yes, I would like to say that in India, so many institutions, they have already leveraged partnerships with the international bodies to regulate ADR training and practice. For example, ICA, that is Indian Council of Arbitration, it is regularly organizing various workshops in collaboration with foreign arbitration experts to share the best practices and enhance procedural skills among Indian practitioners. So ultimately, I would say international ADR bodies, they can set the global standards and help nations build the necessary expertise. So in India, definitely, I would say ADR is not something new. We have, traditional history. We are used to have panchayat systems to promote communal dispute resolutions, where the panches, the senior head of the villages, they used to help parties to, reconcile. And apart from that, the Mediation Act, it talks about institutional mediation, pre-litigation mediation, commercial mediation, online mediation, and emphasis is all mostly on the to maintain the confidentiality of the process and complete it within the time limit prescribed by it. So, and I've already talked about the Conciliation Act, but the one important thing which I haven't touched is in India, we are conducting Lok Adalats, that is People's Court. This is conducted by the legal service authorities, which are constituted under the Legal Service Authority Act of our country, where we are giving speedy relief. The court is there set for one day, and where people from, from the background where they are not very rich, are economically weaker section people, they are coming and the disputes are getting resolved free of cost. And the best thing is the award is like a degree of a court. So it has finality, so that the dispute should not resurface again and again. So this is what in India I would like to say. And apart from that, there is think tank called Niti Aayog, which is trying to, and there are recommendation comings with regard to, online dispute resolution, so that it should reach to the district rural levels of our country. So over to you.
Thank you.
Yeah, thank you.
Thank you. And in the interest of time, may I ask YJ to very briefly follow up if you have anything to add, either on the topic 3 first line or second line question, training on one hand and
in relation
legal
to-
framework on the other hand.
I would just add one comment on the legal training. I think the legal training is very necessary, but there is no institution who's gonna do those training for the developing countries. Maybe ICC or SIAC, they try to do online education, but I would like to propose that Law Asia or IBA or some of the big international institutions, they have to provide some good training sessions to the developing countries. IBA, every year they have IBA Arbitration Day conference and Law Asia as well. So probably the international legal organization may provide training to developing countries. I think that would be very wonderful opportunity to them. Thank you.
So you're talking about the training for mediators, arbitrators, or the counsel, or the users, like
users.
Oh, users. Okay, very good. And Watterson, you have already mentioned something about legal frameworks in Fiji. So may I ask if you can follow up with the first line of the question on topic 3, the training and education in Fiji regarding the ADR. You have seen any developments on that?
Sure. I'll just give a bit more background in terms of the legislative framework, and then I'll answer a bit about the training as well. With our previous government, I mean, they had plans to set up an international mediation and arbitration center in Nadi. And for those of you that have come to Fiji, that's where our international airport is located. And that was supposed to complement an international mediation bill that was supposed to have been tabled in Parliament in 2023. Now, with the changeover in government over 2 years ago, and this government currently has 2 years, I see that I have 2 years now to push, and we hope to revive this bill with the current government and get it back on track. Just some developments in this sense also in Fiji. Fiji Cabinet had approved the review of the High Court and Magistrates Court Act and rules in 2023, with our acting Chief Justice, is now confirmed Chief Justice, then commissioning the setup of the Civil Division Rules Committee. Now the CDRC, this is made up of members of the bench, and they've come up with a final report dated 3rd June 2024, and in there recommending mandatory mediation in all matters begun by writ of summons after the completion of the pre-trial conference minutes and the appointment of court annex mediators who should be legally qualified and accredited mediators. That's the recommendations on the report. Interesting to also note that in the weekend's papers, I see an advertisement by the Fiji Law Reform Commission, and they're now calling for expressions of interest for commissioners to look into the reform of the High Court Act and Magistrates Court Act and rules, amongst other things, to look into the recommendations also provided by the CDRC report. So it's all based on, if you look at the CDRC report, it's all based on case management system within the court system and looking at making the court rules a bit more ADR friendly in that sense. So I'm actually very encouraged by Professor Rajesh Sharma's comments in his keynote speech, and he asked the question, can we finish this unfinished work? And I was asking myself that question as well, and his answer was yes, we can. So that's actually my answer, yes, we can. And the fact that we need to work together and not in isolation is very encouraging to me. Plus, we can't leave this all to George Lim of Singapore to do all on his own. So I'm sure George is in the crowd now smiling at me. George and the Singapore Mediation Center have been very instrumental with the setup of the Fiji Mediation Center and with the training and accrediting of mediators in Fiji. And we've got a whole pool of different people from different backgrounds that are accredited as mediators, and not only legal practitioners. We've got accountants, we've got people from HR backgrounds, we've got civil servants, we've got members of the bench and people with other relevant qualifications, just to add to the diversity. And also the racial mix is quite diverse as well. So yes, I agree that both the bottom-up and the top-down approach must work hand in hand. And if we need to get Fiji to develop into the mediation hub of the Pacific, mediation arbitration hub of the Pacific, that we want it to be, that we need to crack a bit of a whip and get things rolling. Now, with regards to awareness, Fiji Mediation Center is focusing on crediting more legal practitioners in partnership with the Singapore Mediation Center, and much of the same work needs to be done with arbitration as well, seeing as it's important that we get, again, the lawyers buy-in into the whole scheme of things. Fiji Mediation Center, however, faces a bit of budget constraints. It needs to pick up on awareness of its commercial mediation services and help consider, and perhaps rather consider, incentivizing legal practitioners with referring their cases to the center. Other ways that we can try, and get the message across is, interestingly, out of the 3 universities in Fiji, we have the University of Fiji, the University of the South Pacific, and the Fiji National University, all have 3 law schools. University of Fiji, as of 2 years ago, has introduced ADR as a compulsory topic in their Bachelor of Laws program. So I actually teach part-time, and it's a second semester, 3rd year level compulsory unit for their LLB Bachelor of Laws program. So the curriculum is designed to incorporate, I actually redid the curriculum to incorporate international arbitration and international mediation. So we're sensitizing our legal practitioners, from the law school years, so they can keep prioritize or keep mediation and arbitration as as a forms and a means to reckon with when it comes to dispute resolution. Thank you.
Thank you very much. And Ms. Anna, I understand that. Okay, can I? Okay, I just want Misa to very briefly mention the MOJ's very recent, active involvement in the training and legislative aspects, and then and you have the final word for this session. Okay.
Okay. As Mr. Tezukano mentioned, recently Japanese government is taking a very active involvement to enhance ADL use. But I've heard that Mr. Miyazaki from Ministry of Justice of Japan will talk about this topic tomorrow in session 7. So I would like to rely on him. And yes, and I would like to handle to Anne.
Okay, Anne, please, yes.
Thank you. I think I can answer both elements quite briefly. The question of what role do legal frameworks and national policies play, I would say a huge role, absolutely huge. That has certainly been our experience in Australia. Once you have the legislature understanding ADR, once you have the legal profession understanding, once you have the judiciary understanding, things really take off. And in terms of training and awareness, I think absolutely international bodies can play a wonderful role here, like the ADBI ones that you also mentioned, YJ. And the training, there are various groups that can be benefited by such training. So there's the lawyers within government authorities. There's the lawyers in private practice. There's the consumers to get used to these options and know that they are available. So all of those, that's in addition to training the actual mediation practitioners. So there's plenty to do, and it can have a big impact. And on that front, I wanted to say to Watson, I love your optimism, and I can tell you that it's a happy ending to the story, that it really does work, because in Australia now, as I say, like 20 years ago, it was a completely different story. And the landscape has dramatically changed. So it's impossible to get a hearing in any court in the country without going through some sort of ADR process first. And the legal profession who were resistant at first, which is understandable, it is now just part of their everyday life. And it's what the clients want, and it's completely embraced.
Thank you very much. And I'd like to add that in Japan, the practitioners have made efforts to create some nice series of online education videos that can be accessible on-demand basis, free of charge. But I think the challenge is how to make that known to the younger people. It's a nice material, yeah. And now I would like to ask if there is any question from the floor or comments. Yes, please.
Thank you, moderator. I'm from Cambodia. I've got a question to Professor Kim. You mentioned about a impartiality of an ADR settler. What would be the sanction for that impartiality? Because even in judiciary members, the sanction could be disciplinary, civil, and criminal. And how about the case you mentioned? Thank you.
Okay, so there's Japanese Arbitration Act, but there's no like sanction about the lack of impartiality. The only sanction is that this arbitrator have to resign from the case. But yes, I think there's of course the disciplinary sanction if this arbitrator is a lawyer, but criminal sanctions, it doesn't exist.
Except where there is a bribing or some other, I think. And I would like to add that the case she mentioned, there is a point that because the lateral hired partner simply failed to take the formal withdrawal process from the class action, and he entirely forgets about that. So basically, there is no practical way for the arbitrator to become aware of that issue. But if you simply say that, oh, because it was impossible, then the law firms may take a kind of guerrilla tactics kind of position that, okay, we have no effective system to detect the conflict, and therefore there is no conflict. That is not the right approach. So there needs to be a balance between a workable conflict search system within a big firm on the one hand, and then there needs to be some way to make it workable, but not something which requires case by case too much check by the arbitrator, which may take time. And yeah, okay. So yes, please.
Lilith Petrosian from Liamka. First of all, I would like to thank you for the very interesting discussion. And I would like to ask a question about the settlement agreement. So, and this is particularly interesting from the institutional perspective. So what should be the mediators and the mediation institution's response if the parties have a settlement agreement in which they have a term which is evidently conflicting with the law? For example, it's a labor dispute, and the parties agreed that, and one party agreed that, for example, he will work for more hours than it is defined in the law. What should be the mediator's response, and what should be the institute's response? And will this be a problem from the side of the impartiality? Thank you.
Any speaker to comment? Yes, Anne, please.
Sure. As a mediator, I'll do my best. It's a question that comes up very often in training mediators. And in Australia, and it'll be different in your different countries depending on the level of regulation of mediation that you have. There are some areas, I'll try and keep this, like most lawyers, it's hard to give a short answer. I'll try and keep it short, but the answer is different in different contexts. If you were mediating within the system of our like industrial relations system, which at the moment is called the Fair Work Commission, you would be the mediator there is actually what we would call a conciliator, meaning they have a duty to uphold the act. So it would be clear for them, they can just say, well, that's not an option. That's outside the law. It becomes more interesting and more tricky if you are in a private mediation context, where it is then genuinely what I would call an ethical dilemma for the mediator. If it is not something that's regulated by law, then it falls onto our ethics. And the first port of call, and then like in any ethical dilemma, there are a range of responses the practitioner can make along a spectrum. Some practitioners might think, well, in the spirit of mediation, this is private contracting. It's not my job to judge. It's none of my business. Then other mediators, like myself, I would think I'm not comfortable with being part of something that's illegal, but I don't have a direct obligation to report it. I wish I did, because then everything would be easier. The first thing I am going to do as a practitioner is, in private, reality test the parties. So I won't go into detail about that. I can see people who are mediators, their heads are nodding. I see Rima nodding in India. That we know we have a bunch of skills to use before we have to run from the building, so to speak. At the other end of the spectrum, you might eventually say, I'm sorry, I can't be your mediator. But hopefully, in the spirit of mediation, which is all about negotiation and finding what's truly in the interests of people, we reality test the party. We ask those questions about, well, what will be the consequence for you if this was to come to light? And hopefully they can see that working within the law will be better in the long run.
One of the hot topics is how to deal with the proposed mediation settlement or the proposed consent award, which may look like a kind of leeway for money laundering or the evasion from the sanction. And I don't know whether that is the task for the mediator to somehow deal with the situation, or if there is any mediation institution which takes a responsibility in monitoring that. But this is quite an hot issue, and perhaps in the training of mediator, such kind of a potential issue may be a part of the few things a mediator needs to know. Okay. Okay, Takatori Sensei, the final question.
Okay, final. Oh, I should be responsible. Thank you very much for the excellent sessions. I'm the Yoshitaka Tori, the mediator for the JMC and ISMC and also JCA. So my question or comments, 2 points. First one is the regarding the accessibility. I think the publicity should be the key, and I completely agree with the YJ. The education to the user side should be the key, and then even among the users, I think the most significant training or education should be conducted onto the in-houses, I think, who has the kind of business interests, understanding, and legal issues. So the in-houses role should be quite significant, especially for the mediation. That's my first comment. And then second is the regarding the impartiality. Even for this same term for the impartiality, I can see some slight difference between the necessary impartiality for the arbitrators or mediators. And even among the mediators, depending upon the mediation is a facilitative one, which does not have any decision making, or some evaluative mediation, which has a decision making kind of evaluation type. So then maybe kind of impartiality could be more significant. That's my kind of feeling. So I would like to invite your comments for any sense for those points. Thank you.
Perfect comments. And I'm wondering if you have any additional comments. YJ? Okay. Thank you very much. And please ask you to join me with a lot of applause to the excellent speakers. Thank you very much. The clock on the wall is 3 minutes behind. Okay.
Thank you, Mr. Tezuka, and beautiful discussion with distinguished panelists with a diverse perspective of view and beautiful time management. And let's move on to 25 minutes of coffee break with caffeine and networking. And please come back to room at 3:40 for session 3. Thank you.
Okay, thank you everyone, and have a good day.
Thanks, everyone. I think we're taking a group photo, Rima, smile. I mean, our panel photo. Oh, that's probably already done.
We are missing it.
Thank you, Ms. Rima and Mr. Nata. Thank you for joining us.
Thank you.
Thanks very much. Thank you for having us.
We are missing the group photo, actually. That's what we are talking. Okay, now, thank you. Yeah. Okay, bye-bye. Bye.
Okay, see you, Rima. Bye-bye.
Yeah,
Have a
see
good
you
one.
soon.
Keep in touch.
Yeah, be in touch.
Will
Yeah.
do.
Yeah.
Yes.
Take care. Bye-bye.
Yeah. Welcome back, everyone. I hope you're feeling refreshed and ready for our final session of today. Then let's begin the session 3, current international ADR in developing countries in Asia and the Pacific. In this session, government officers, including senior government officers from Asia Pacific countries, will provide the latest and on-the-ground updates on the implementation of ADR in their respective countries. And Ms. Bo Young-jang, the Senior Capacity Building and Training Specialist of ADBI, the project manager of this conference, will lead this session. And let me introduce her, and the floor is yours.
Thank you, Yeon-jung, for your kind introductions, and welcome all of you to the country presentation sessions. I'm Bo Young from ADBI, and I'm very pleased to moderate this session with all these distinguished speakers from our member countries. So today, given the size of group, actually we have 7 presentations here. So we decided to divide this session into 2 parts. So first, we will hear from Uzbekistan, Cambodia, and Armenia, followed by Q&A session. After that, we will transition to the presentation from Indonesia, Philippines, Malaysia, and Kazakhstan. So in the previous sessions, we heard from the arbitration institutions, experts, and practitioners about these areas. But this session, we will hear the government perspectives of ADR and their actions, efforts, and initiatives. Yeah. And then all countries have very diverse legal and institutional frameworks. By examining each country's approach in depth, we hope to foster a better understanding of ADR practices and explore potential solutions to common challenges. And to ensure the smooth proceedings, I kindly ask all speakers, keep your presentations within 7 minutes. You have 7 minutes, and I will ask Mingyang to help me to keep the time. We have 2 cards, yellow cards and red cards. Could you show me the yellow card for 2 minutes left, and the red card is time's up. So when you present, please see this card, and then please keep the time. So let's begin with our first speakers. Our first speaker is Miss Sevarkon Marifova from Uzbekistan. She is a chief consultant. Sorry, it's actually the speakers keep changing. So I'm very sorry. Yeah, so who will be the speakers?
She will speak.
Okay.
She's a professor at the Lawyers Training Center at the Ministry of Justice.
Yeah, right.
Yeah, she's the one who founded the mediation courses back in Uzbekistan.
Oh, thank you so much for your introduction. Ms. Marifova is the head of the Department of Private Legal Sciences, Ministry of Justice, Uzbekistan.
Dear distinguished guests, colleagues, it's a pleasure to have the opportunity to speak with all of you today. Let me begin by providing a brief overview of the history of mediation in Uzbekistan. The roots of mediation in Uzbek law can be traced back to ancient times, particularly during the era of Mavrannahar, with the region served as a hub of culture and civilization, housing some of the most important cities of the Islamic world at the time, including Samarkand, Bukhara, Shash, Naqshband, Fergana, Khujand, Turkestan. The justice system of this state was robust, with the Samarkand and Bukhara schools of law being particularly prominent. One distinctive aspect of this system was the practice of mediation, which took place before any formal trial proceeding began. The intermediaries in the system were called muhtasib, and they were appointed by judges, so-called qazı. Among individuals who were highly respected by the local community, where main responsibility was to resolve disputes directly and avoid escalating the issue to the court, helping to maintain social harmony. The judge would periodically compensate them from their own funds and evidence in historical records. Importantly, these services were provided free of charge to the public. Typically, muhtasibs carried out their duties in busy markets and remote villages, ensuring peace and conflict resolution where it was most needed. This system was effective for centuries, but things changed when selfish judge arranged for the muhtasib to be paid from Hazna. As a result, the original purpose of the mediation system was lost, and it ended up becoming more about inspection instead. One well-known example of mediation in Mavrannahar is the case where is the life of the famous philosopher Avicenna, Abu Ali ibn Sina. Abu Ali ibn Sina was saved by the muhtasib of Bukhara, Shams al-Imma Halwai. Avicenna, due to his experiments with exhumed corpses, was accused of grave desecration by his enemies and faced of death penalty. The crowd was ready to demand his execution. But someone suggested taking him to the Muhtasib to explore other possibilities punishment. Avicenna agreed, and the court brought him to the Muhtasib. After mediation, the Muhtasib ruled in Avicenna's favor, issuing a document stating, Avicenna is not a grave desecrator, and allowed him to go free. Shams al-Ulema Halwai was not only known for producing and exporting halwa, but was also a respected Islamic scholar. These documents later become a fatwa, religion rule, permitting autopsies to be performed to determine the cause of death and allowing medical treatment on living people. Now, let I shift your focus to the present and talk about how mediation works in Uzbekistan. Can we change slide? Можно поменять? Slide okay, thank you. Thank you very much. Specifically, we will dive into the mediation law, which serves as a foundation of the system. The law, which was adopted in 2019, applies to disputes related to civil legal matters. This includes issues arising from business activities, labor disputes, and family-related legal matters. The mandatory pre-trial mediation process is required for issues related to foreign investment and investment disputes in Uzbekistan, as well as collective labor disputes. Mediators are classified into professional and non-professional categories. Non-professional categories mediators offer their services for free, while professional mediators are trained, certificate, and registered in official list. The first training courses for mediators were launched by the Lawyers Training Center and the Ministry of Justice on September 2019 with 144 hours program. Currently, only 2 centers offer mediator training, which courses lasting no more than 72 hours. Our 3,000 people have completed the training so far. As of February 2025, there are near to 2,000 registered professional mediators, including almost 400 added in 2024. Around 62 of them are notaries and lawyers. The total mediation period is up to 30 days, with an extension possibilities for an additional 30 days. Mediation can also take place during the enforcement of court decision. In these cases, mediation is carried out only by professional mediators and must be completed within 15 days. Between 2021 and 2024, notary mediators have concluded over 200 mediation agreements. Today, a draft law aimed at further expanding mediation opportunities has been developed. This draft law will allow disputes to be resolved through mediation between clients and banks, as well as between consumers and insurance companies. Here is interesting fact to share. In 2023, alone, Uzbek courts handled 150,000 cases related to bank clients disputes and 27,000 cases involving insurance contract, which together made up 12 of the total court cases.
Ms. Marifova, could you wrap up your presentation?
Okay.
And
Okay.
shortly.
Okay.
You finish shortly.
For next slide, can we show next slide? Okay. In this next slide, we are playing it, changing the law of the Uzbekistan regarding mediation. Next slide, please. Oh, thank you very much.
Thank you, Ms. Marifova. Your introduction of the mediation history was quite interesting, but yeah, we missed some yeah slides from yours, and now let's move to the next presentation. So we will hear from the Mr. Sorfon San, Undersecretary of State at the Ministry of Justice of Cambodia.
Good afternoon, everyone. Well, I will be very short because I've got permission from my superior hierarchy. ADR now covers two parts in our country. You see in the slide, we've got the National Authority for ADR, but this an ADR does not cover arbitration. The National Authority for ADR was not created by legislation, by law itself, but because the need of reducing bad luck in the judiciary. We've got a lot of criticism as to the court, all courts of Cambodia as too slow in deciding all cases, criminal cases, civil cases, and commercial cases, including, of course, labor cases. That is why in 2023, only about a year and 2 months ago, we've got a royal decree from our head of state creating this national authority for ADR. A royal decree is for its hierarchy is one level below the law, below legislation. So the Ministry of Justice proposed the draft royal decree to the government, and the government submit directly to our head of state to create this national authority. The national authority is a hybrid mechanism of ADR, because in our history, we've got a long history of conciliation. So normally a civil case, we go to the chief of villages, we go to the head of religious to solve this. And after that, we've got a modern notion of mediation, especially from the influence of the Singapore International Convention on Mediation. So it's a combination of conciliation and mediation. So we are about a year and 2 months. So we've got a lot of cases. We've got right now 466 cases for 1 year, and then we've got 151 mediated. Comparing to our colleagues, National Center for Mediation, for commercial mediation, it was created about 1 year as well, and they got only 3 cases. And what we've got a big difference between National Authority for the ADR and Commercial Center for Mediation, which is under the NCAC, National Commercial Center. Our National Authority under the Ministry of Justice is free of charge. It's free of charge. It's a public service, and the government put it in the priority of the new government in the new government. So the Prime Minister says, in order to stop criticism of the judiciary, the Ministry of Justice need to reduce bad luck from the case, from the court. That's why the service provided by the National Authority for ADR is free. And the second thing, why I say it's hybrid system. Normally, it does not binding or for no, it's not binding. For mediation, it ups to the party to settle their agreement with the mediator. The decision of the settle agreement of our National Authority for ADR is deemed first instance of court decision, so it's binding. That is why it's hybrid. Normally, in mediation we don't have it. So this second characteristic of our National Authority for ADR, and with the rapid solution of the cases, we also faces face some challenges. We are very new, so we need technical assistance from our friends in ASEAN, in Asia, or international institution like UNCITRAL, like from Singapore, from ADB, to help our national authority for ADR. Of course, ADB presented here by Krishna Park, she helps us a lot with the establishing of the commercial court, including commercial mediation. And secondly, we are working, our group of commercial court are working with a national authority for the ADR to initiate the drafting of mediation law, which is we've got assistance from Ministry of Justice from Republic of Korea, and we plan to do this in a short time. With ADB, we also have we could participate in CFOC meeting, where we got a lot of information from CFOC to help our judges. In short, for mediation, including arbitration, and for ADR, including arbitration and mediation, the government favors a lot this mechanism because you can reduce a deadlock from the court. And as for mediation, for arbitration, we've got a national mediation center which is created in 2006, 2 years after our session to WTO, and they established the real functioning of our national center for arbitration. It was in 2013, and right now it's about 10 years. The national commercial arbitration received 47 cases. 47 cases. As for the challenge of our national arbitration center, they need to build the capacity building for our arbitrator, and they need to work more on international relations. Thank you for your attention, and I will be very pleased to answer to our ADR mechanism. Thank you.
Thank you, Mr. San, for your presentations. Now let's invite our third speakers. Our third presentations will be from Armenia. So Mr. Tigran Dedunç, Deputy Minister of Justice, and Mr. David Karipian, Acting Director at the Center for the Legislative Development Foundation, will present together.
Thank you. Thank you, dear partners, dear colleagues, ladies and gentlemen. It is my pleasure to represent the Republic of Armenia, Ministry of Justice, in this very high-level conference. And firstly, I would like to extend my sincere gratitude to the Asian Development Bank, ADBI Institute, UNCITRAL, and Ministry of Justice of Japan for organizing this event. As an introduction, I want to highlight some key areas where our government has been actively engaged to create a more favorable environment for ADR development. Without such steps, it would be difficult to foster international arbitration, especially in a jurisdiction in a country like Armenia, where the field is still developing and operates on a comparatively smaller scale. In the past years, the government of Armenia, the Ministry of Justice, have taken some major steps towards the development of ADR. Our objective has been to create a more predictable, more effective legal framework for local and international dispute resolution, align domestic ADR legislation with international legal developments, best practices, take steps to reduce courts overload, and to expand the scope of arbitration and mediation to ensure faster dispute resolution, to position Armenia as a emerging jurisdiction for ADR by creating a new state-of-the-art international arbitration and mediation center to improve the quality of education, trainings, to modernize um, ADR processes through digitization, and most importantly, to promote mediation and to create a new community of mediators in Armenia. But despite this progress, we still face challenges, such as aligning ADR with domestic legislation to overcome cultural differences, bringing international business cases to local dispute settlement, to local arbitration centers, rising public awareness and trust in ADR overall. But I'm sure that these challenges are not unique to Armenia, and I believe that we can learn from each other to find better solutions. And again, I want to take this opportunity to sincerely thank ADB for its strong support in Armenia's journey for implementing the mentioned reforms. And ADB's assistance has made a significant change, and we're looking forward to this continuing partnership. This is from my side, and I want to pass the floor to my colleague David Garibian, who will continue on policy reforms in more details, please.
Thank you. Good afternoon, dear colleagues. For me as well, it's a great pleasure to be here today and to present the recent legal reforms that my home country, Armenia, has undertaken in the field of alternative dispute resolution. Over the past few years, we have made significant progress in both mediation and arbitration, strengthening our legal framework to promote faster, fair, and more efficient dispute resolution mechanisms. And I'm hopeful that the experience sharing during these 2 days will benefit all of us to learn from each other and to develop our countries further. Starting with the mediation reforms, in this area we have introduced several key developments. For example, mandatory mediation was introduced by law, and certain family disputes will undergo mediation processes before proceeding to court. Next, to make mediation more predictable and more accessible, we have introduced fully digital mediation processes, allowing parties to resolve their disputes in a digital and efficient manner. Meanwhile, Armenia also signed the Singapore Convention on Mediation back in 2019, and now we are actively working on the ratification progress of the convention and the necessary legislative amendments to ensure its proper implementation in our jurisdiction. To ensure the operability of the mediators community, we have established a self-regulatory organization of mediators, and this organization has a key role in ensuring the professionalism and independence and ethical standards in the mediation process. Last but not least, and also thanks to the support of Asian Development Bank, during the last year, we have introduced 5 specialized training programs based on international best standards. Due to this, 125 mediators have been accredited and are now actively supporting to the resolution of disputes. Now turning to the arbitration reforms, we have implemented several crucial developments. One of our proudest achievements, our baby, as our colleague from Asian Development Bank, Christina Pag, usually mentions, is the creation of the Arbitration and Mediation Center of Armenia. And this center, despite only 1.5 years of its operation, has already administered successfully both local and international arbitration and mediation cases, which is reinforcing Armenia's reputation as a reliable jurisdiction for ADR. And again, this reform could have not become reality without the strong support of the Asian Development Bank. I believe if we talk about the ADR reforms in Armenia, we can see that ADB is always there, and we hope that this contribution and cooperation will continue further. Continuing on arbitration reforms, we have made some changes in civil procedure legislation, where the enforcement and annulment of arbitral awards procedure has been revised to introduce shorter timeframes. This is in order to ensure the arbitration remains a swift and effective alternative to litigation. And another, I would say, non-ordinary reform was that arbitration institutions have been granted power to execute enforcement writs instead of the courts. This is if the parties are Armenian residents and the dispute amount does not exceed 12,000 drams. I believe this is not something that we can see everywhere, but because of this reform, more than 40,000 small claims arbitration cases are being directed to enforcement authority annually. In the end, I would like to tell about reform which is neither in the area of mediation nor arbitration, but to my understanding, it is another clear form of ADR. More specifically, from now on, banks, credit organizations, utility service providers, and mobile operators have to submit their debt enforcement claims to notaries instead of courts. And these reforms are if the amount does not exceed 5,000 US dollars. And because of these reforms, we have already reduced the backlog of civil judges by 83%. This is 6 times less than it was in the previous year, and it showcases how important was this reform in the overall justice sector development. All the mentioned reforms mark a new chapter in Armenia's commitment to creating a strong and efficient ADR system. By enhancing mediation and arbitration frameworks, we are not only improving access to justice, but also positioning Armenia as an attractive destination for dispute resolution in the region and beyond. Thank you.
Thank you for your clear presentations. And then the policy reform, you introduced the policy reform, and it was very valuable and insightful. Thank you so much. And I think we have almost 7 minutes Q&A sessions. And so now I will open the floors, and please ask questions related with the presentations of these 3 countries. So when you ask a questions, please specify to whom this question is addressed. So if anybody has questions, you can allow 1 or 2 questions. No questions. No questions to the, or then may I ask? Okay, so it's not actually it's not so much questions. But I mean, we don't have enough time to present your legal systems. I'm very sorry to rush all of you. So I want to give you 2 minutes more to speak about more speak about the international ADR. So I think the most countries have quite good usages and frameworks for domestic disputes, especially mediation. So, but now we are talking about more about the international commercial or investment disputes. So in this context, could you a little bit elaborate about your country situation?
Yes. Thank you very much for the question. So I believe when it comes to Armenia, we have a single unified law for both investment and commercial arbitration. It's the law, it's called the law on commercial arbitration, but it regulates both. And here, when it comes to the national interests of Armenia, how they are being represented, we have under the Prime Minister's office, there's another office which is called the Office on International Legal Representative. And this office is dealing with the representation of Armenia in several international disputes, including ones in the arbitration. The statistics show that the most disputes that Armenia is engaged, although the overall number is not big, and I believe it's good because this shows that we are not so bad in doing business with the investors, are undergoing through exit. But also we have some commercial arbitration cases too, which usually go to PCA, ICC, or LCIA. And here, what we can see, the tendency is that most international disputes that Armenia is a party to are regarding to the construction sector or energy sector. These are the main growing sectors because we are undergoing a lot of construction now and energy. And to our understanding, it is quite natural that if you are doing something too much, then there's a possibility that the dispute should be there too. But hopefully the ratings also say that we are quite successful in the disputes that we have. And I hopeful that not like we will not have disputes, not like we will be successful always, but we will not have any disputes further.
As for Cambodia, in terms of arbitration, we are fine with that. We've got a well-functioning institution, National a Center for Commercial Arbitration, and we've got around 77 trained commercial arbitrators. We are member of New York Convention. We are also member of International Center for Investment Dispute Resolution, and it's quite quick for the commercial arbitration. But as for mediation, we are very new to this. So our national authority was created by a royal decree. It's not by a law yet. And so among the we are not yet the member of Singapore Convention, nor the member of an UNCITRAL model law on mediation. And we've got a lot of questions why Cambodia has not access to the Singapore Convention, which is a country in ASEAN country. We are still riding a bike and motorcycle. And our friend says, why don't you need to buy a plane? So, well, it's the development, the social and political development of the country. We are not yet ready for this. So in order to do this, that's why we have technical assistance from ADB and from other friends, for example, from Republic of Korea, to initiate our draft law on mediation.
Thank you for your answer. Yeah, I totally understand. So, Uzbekistan.
Just a quick remark. Could I add? Yeah, thank you. Oh, okay. So basically, right now in Uzbekistan, we're about to ratify the Singapore Convention, and all the necessary actions are being carried out. And besides that, the mediation and arbitration as alternative dispute resolution is being widely implemented. For example, the investment agreements signed between the government and investors, most of them are including the mediation clause. I mean, before proceeding to the arbitration on the dispute, investor and the government should take the mediation process. So basically, that's a quick remark. Yeah, thank you.
We have one question from online, if it is okay. Yeah, could you read out? Yeah.
Yes, there is one specific question for Uzbekistan. I will read out loud. Western secular experience with mediation promotions in society is often not similar to Oriental cultural religious societies where the factor of domestic practice and belief play a central role. How important is it to integrate such cultural religious value within such training to create sustainability in mediations in that jurisdictions and not a one-off training effort with limited impact?
So as far as I understood, it was about cultural mediation. Yes, about religious. It's widely practiced in Uzbekistan. We have the mediators who practice, who help to resolve the issues related with religion, with culture. Because as you know, Uzbekistan is there are lots of cultures, so that's why it's widely implemented, and all the opportunities and all the necessary things are available. Thank you.
Thank you for your answer. So thank you all of our speakers, and let's give them a big round of applause. Yeah. And thank you, our speakers. You may return to your seat. And now let's proceed with our second group of presentations. I invite our speakers from Indonesia, the Philippines, Malaysia, and Kazakhstan to come forward. Yeah. Take a seat, please. Yeah, you can sit any place. Anyway, we will start with Indonesia. Yeah. So given the time constraint, let's move straight to the next presentations. First, we have a Honorable Miss Justice Rojana Kesuma Hidia from the Supreme Court of Indonesia. Yeah, please take the podium.
Good day, everyone. Thank you for the time. Great honor to me to be the speaker at this moment. My presentation, can you share? I would like to presentation about mediation as an alternative dispute resolution in Indonesia. There is two role of judges in Indonesia. The next slide. Judge as a decision maker and judge as a mediator. Why mediation is important in Indonesia? Because as an effort to encourage every dispute resolution towards the national identity, the next slide. The next slide. Because as an effort to encourage every dispute resolution towards the national identity, namely deliberation and consensus, as stated in the fourth principle of Pancasila, and realizing the implementation of simple, fast, and low-cost justice, and increasing access to justice, the role of the judiciary in improving Indonesian ease of doing business ranking in the context of civil law from a commercial aspect. The next. There is the characteristics of mediation in Indonesia. The next. There are two legal bases of mediation in Indonesia. The first, mediation in court, and out of court mediation. The second. The next. This is scope of mediation. Regarding mediation, procedures apply to all civil cases in court, within the general court and religious court, except for cases that are excluded from mediation by Supreme Court regulation, just for general court and religious court. The next. Cases that are excluded from mediation by Supreme Court regulation. The first, dispute for which a time limit for resolution is determined in court includes, among others, dispute resolved through commercial court procedure like bankruptcy, intellectual property right, and competition law. Dispute resolved through court procedures, industrial relation, objection to the decision of the Business Competition Supervisory Commission, objection to the decision of the dispute resolution body consumer, application for annulment of arbitration awards, and etc. You can see. The next. Dispute whose examination is carried out without the presence of the plaintiff or defendant who has been duly summoned. In the next, counterclaim. Okay, provision regarding mediation. Every mediator must have a mediator certificate from the Supreme Court or a certification body accredited by the Supreme Court. If there are no or limited number of certified mediator in the court, judges who are not certified mediators can perform the function of mediator. Court employees can be the mediator too. And about mediation certification in the Supreme Court of Indonesia, the institution that carries out mediator certification is a Judicial Training Center. There are 4 types of mediation. First, mandatory mediation. Mediation must have been undertaken by the parties before the case is examined by the panel of judges. The mediation period is 30 working days and can be extended for a maximum 30 working days too. And the second, voluntary mediation. Voluntary mediation conduct after mandatory mediation files, and the process is 14 days from the date of mediation order. And the third, mediation at the legal remedy stage, and the last, mediation outside the court. Next. The next. Next. Yeah. Presence of the parties in the mediation process. It can via long distance audio-visual communication media considered as direct presence. The parties are required to attend the mediation process in person with or without being accompanied by legal counsel. Absence is permitted only for valid reason. And mediation must in good faith. The next, mediation must be conducted in good faith. The provision of good faith in the mediation process apply to the parties and their legal counsel. Indicator of bad faith is you can see not present in the mediation process even though he was summoned twice in a row, not submitting or not responding to a case summary, not signing the draft peace agreement, present just at the first mediation meeting but subsequently did not attend even though he had been summoned twice in a row. If a plaintiff not have a good faith, the lawsuit is declared inadmissible and the plaintiff is required to pay the mediation fee. And if defendant is not in good faith, the mediation fee will be charged and the mediation fee will be passed on the plaintiff. The next, mediation cost. And the next, mediation result. Yeah, mediation, the first mediation can be successful. If mediation is successful, the peace agreement can be strengthened by the peace deed or withdrawal of the lawsuit. And if mediation was partially successful, the examining judge will continue the examination of the case regarding matters not agreed upon by the parties. The examining judge must include the agreement in the consideration and ruling decision. And mediation can be unsuccessful. The next. Okay. Okay, mediation can unsuccessful. Mediation cannot be plain. And this is the last. This is dispute resolution through mediation. This is I have data table case settlement mediation in district court and religious court in 2024. And this is the list of country to which the summon notification document in mediation. Okay, thank you. That's all. My friends will continue.
The time is up. So after all the presentations, if we have time. Yeah. Thank you. Yeah. Thank you for your presentations. Next, we welcome the Ms. Reynalyn Pidalon Barias, Director 3 of the Office of Alternative Dispute Resolution at the Department of Justice of the Philippines.
Good afternoon. Good afternoon. I'm Rain Farias. It is truly an honor at the Department of Justice Office for Alternative Dispute Resolution to present the Philippines at the ADR Policy Dialogue. In this presentation, I will provide a brief overview of the Office for Alternative Dispute Resolution, or the OADR, including its programs and services. First, let me introduce to you the law that formally established our office, the Republic Act Number 9285, also known as the ADR Act of 2004. This law institutionalized the use of ADR system in the Philippines. While ADR has a deep historical roots in our legal system, with laws encouraging practices like arbitration and negotiation, long before 2004, the ADR Act marked a significant step in formalizing and advancing these mechanisms at the national level. The Republic Act 9285 established the Office for Alternative Dispute Resolution, or OADR, as an attached agency to the Department of Justice. Our primary mandate is to promote, develop, and expand the use of ADR across in both the public and private sectors. We aim to reach more people and help them understand and appreciate the benefits of ADR. To provide you with a clearer understanding of the services offered by the OADR, let's briefly go over our key programs and services. We offer training programs, accreditation, certification services. We offer and public information initiatives. Additionally, we serve as an appointing authority, contribute to policy development, and maintain a resource center for public access. One of the unique aspects of the ADR system in the Philippines is the katarungang pambarangay. While there may not be a direct translation of barangay in your language, barangay is the smallest administrative unit of government in the Philippines. Katarungan, on the other hand, translates to justice in English. The Katarungan Pambarangay system promotes the use of ADR at the grassroots level, where the local government unit, specifically the barangay, plays a key role in managing disputes. Before a case reaches the judiciary, the barangay ensures the efforts are made to resolve disputes amicably through mediation, conciliation, or arbitration. This system filters out cases that can be settled outside of court and empowers local leaders such as the punong barangay or the barangay captains and the lupong tagapamayapa or the peacekeeping council to resolve disputes within their jurisdiction. The OADR supports the implementation of this system, but its effort to capacitate the actors of the barangay through the course that we offered for them. This course was also one of the programs within the Justice Sector Convergence Program, where we prioritize the justice zones. So how does Katarungan Pambarangay work? It operates similarly to the regular case filing process, like in our criminal courts, but with distinct advantages. Disputants have the opportunity to present their cases without the need of lawyers, allowing them to reach a mutually agreeable solution while preserving their relationships. It is also cost-effective as a procedure is typically free and takes place within their community where the parties reside. Once a case is filed, the respondent is notified and invited to a scheduled mediation session with the lupong tagapamayapa or the peacekeeping council. If the mediation before the punong barangay fails, the case is referred to the lupong tagapamayapa, which will form a pangkat na tagapagkasundo, or what we call conciliation committee, to facilitate further conciliation proceedings. This extended process allows the parties to be heard again with the goal of reaching a mutual agreement. At any point, the parties may opt for arbitration where the punong barangay or the pangkat tagapagkasundo can propose a resolution to the dispute. Through this system, parties are offered creative and cost-efficient ways to resolve their issues. Only if these efforts fail, the case will be escalated to the formal courts and the barangay captain will issue a certificate to file action. When we examine the ADR systems in the Philippines, the Katarungan Pambarangay stands out as the most trusted. This is primarily due to its accessible and cost-effectiveness. Additionally, it plays crucial role in reducing intimidation, often associated with formal rules of court, make it more approachable for the community. Since the enactment of ADR Act 2004, the Philippines has embraced its used across both judiciary and executive branches of our government. As a result, we've seen a positive settlement rate across all all ADR systems. The Katarungan Pambarangay continues to lead with a 78% settlement rate and handles the highest number of cases, followed by cases managed by the executive branch. It's also important to note that even the judiciary has adopted ADR with mediation now being mandatory in all civil and certain criminal proceedings. While not all cases are subject to compromise, any case that can be resolved through ADR should be processed within the ADR system, whether in the judiciary or administrative bodies of the government. Despite the effectiveness and widespread of the use of ADR in the Philippines, the Office for Alternative Dispute Resolution still faces challenges in promoting the system. One of the key challenges is building confidence and ensuring widespread acceptance of ADR as a viable alternative to traditional litigation. Many individuals and organizations still prefer litigation, often due to lack of familiarity with ADR process or misconceptions about its efficacy. Another significant hurdle to securing legislative support for the continuous updating and enhancement of the ADR Act as the legal landscape evolves. It is crucial to ensure that the ADR framework remains relevant and responsive to the needs of the public and changing dynamics of dispute resolution. The ADR advocates for necessary reforms and adjustments to strengthen ADR practices and ensure they are in line with the global standards. Furthermore, there is a need for ongoing research to evaluate the effectiveness of ADR systems and the ADR services. This research will help measure the impact of ADR in resolving dispute efficiently, fairly, in a cost-effective manner. Additionally, it will guide improvements in the delivery of ADR services, ensuring that they meet international best practices and standards for quality and fairness for dispute resolution. Addressing these challenges requires continued collaboration for lawmakers, stakeholders, and public to advance the ADR framework and increase its integration into both and public sectors. I hope this platform serves as a vital avenue for continued collaboration and support between the OADR and the international community, helping us to achieve our mission to promote and institutionalize the effective and ethical use of ADR in the Philippines. By engaging in global counterparts, we can share best practices, gain insights, and international experiences, and ensure our ADR system are aligned with global standards. The OADR envisions a society that rises above conflicts, where individuals and organizations are empowered to resolve their disputes through fair and just means. Through international collaboration, we can further strengthen our ADR framework, ensuring it will provide accessible, equitable, and effective solutions to all parties involved. Thank you.
Thank you so much. I am very sorry for all the speakers. I think these two cards are really pressure to all the speakers. Thank you for your presentations. And it was particularly interesting. The Philippines has a dedicated office for the ADR itself. So thank you so much. And then let's move to the next presentations. Our next speaker is Ms. Rajendram Franklin Sharif, Federal Counsel at the Attorney General Chambers of Malaysia.
Good afternoon, everyone. Now, I'm going to attempt the impossible since I've got the side eye on finishing it on time. So I've kept my slides to just 4 slides. Slide, please. So I will be covering Malaysia's current use of international ADR, the legal framework of ADR in Malaysia, and the government plan in promoting international ADR. Next slide, please. All right. So for the current usage of international ADR, now Malaysia takes a stand that we have got arbitration, mediation, and conciliation as something that we generally use. And if you would look at the slides, being a not newly, but we are a recognized hub for international arbitration. And it's being currently largely driven by our legal framework and strong institutions. The main institutions for ADR in Malaysia is the Asia International Arbitration Center, AIAC, as well as the Malaysian International Mediation Center, MIMC. We also have court-annexed mediation centers as much as our other counterparts. And we have used and participated in ICSID as well as UNCITRAL matters. So for ADR, in relation to arbitration, most of our cases would go to AIAC. And AIAC is driven by our legal framework of arbitration law. And the Arbitration Act 2005 is based on the UNCITRAL model law on international commercial arbitration, and this aligns Malaysia's arbitration practices with international standards. Now, Malaysia has also adopted the New York Convention, and this allows the enforcement of international arbitration awards. As for mediation, MIMC is the one that is basically managing the international ADR. It is actually a division in the Bar Council led by the practicing lawyers of Malaysia, and they are actively promoting mediation for both domestic and international disputes. AIAC as well has cases on mediation, and these are the main key institutions that are doing international mediation cases in Malaysia. Next slide, please. Now, these are the legal frameworks of ADR in Malaysia. We have the Arbitration Act 2005, Mediation Act 2012. The Arbitration Act covers arbitration matters. Mediation Act, of course, would cover mediation matters. Now, the Industrial Relations Act and the law reform would basically be for the conciliation matters, although these are mostly domestic cases. I've also included UNCITRAL, the New York Convention, as well as the Singapore Convention that we have signed, but these are basic models that we refer to. Next slide, please. So for the government's plan in promoting international ADR, we have firstly institutional support. The Malaysian government recognizes the importance of promoting ADR, and as such, it has looked to strengthen the institutions that we have. Firstly, AIAC is equipped with advanced facilities to host international arbitrations. It has also been engaging with other global ADR bodies to improve its standards as well as visibility. Malaysia has also been part of international conferences and forums and have also hosted both of the same. As for the legal and policy reforms that we have actually upgraded our Arbitration Act as well as our Mediation Act. It has gone through several amendments. In fact, the AIAC's rules itself have gone through several amendments to it, with the latest being last year, sorry. We also go through promotion of ADR in key sectors. Now we have done awareness campaigns. We have also done MOUs, for example, between AIAC and the Asian Football Confederation. Now these promote ADR, and don't worry, I'll finish on time. And of course, court-referred cases are mostly domestic cases, and very rarely we see international disputes being coming from court annexed mediation. So we have also participated, as I mentioned earlier, in the UNCITRAL Working Group 2 and 3. We have currently a Financial Markets Ombudsman Services, which was recently established this year, and it serves as an alternative to the judicial system through the provision of independent and impartial mediation and adjudication services. It is the streamlined and consistent dispute resolution process, which also enables quicker and transparent resolution for both consumer and investors. Now, we also have educational training initiatives. It is run by AIAC as well as MIMC. Both have their training programs. We also have public awareness campaigns, as the government does recognize the importance of ADR in this matter. And I'm done. Thank you.
Thank you for your presentations. And I think, yeah, Malaysia has quite well established ADR frameworks. Yeah, thank you so much. And our final presenters, yeah. Lastly, we will hear from the Mr. Yalon Tuyakbayev, Director at the Ministry of Justice of Kazakhstan.
Thank you. Good afternoon, esteemed colleagues. It's a privilege to join you today to discuss Kazakhstan experience in supporting the development of ADR. My name is Yerlan Tuyakbayev. I am a head of department for the protection of states' property rights of the Ministry of Justice of the Republic of Kazakhstan. The main function of my department is to address international claims issued against Kazakhstan in its state's agencies. In my work, I usually find myself before the arbitral tribunals, foreign judges, or trying to peacefully settle the disputes in mediation. Next slide, please. Next one. To begin with, Kazakhstan has made a significant progress in integrating arbitration into its legal system by introducing the law on arbitration in 2016 that was guided and inspired by the UNCITRAL model law. This approach helped us to strengthen party autonomy and reduce judicial intervention. Kazakhstan has been a party to the New York Convention since 1996, and its civil procedural code reflects the country's pro-arbitration approach, obliging the judges first to attempt to conciliate the parties before hearing the merits of the case, and also to offer to resolve the dispute in ADR. Next slide, please. Speaking about the institutional development, in 2017, Kazakhstan has established the Astana International Financial Center, International Arbitration Center, operating to the highest international standards. The procedures and standards at the IAC seek to follow international best practice and are familiar to users of arbitration and mediation services in major financial centers around the world. Thus, along the other leading financial and dispute resolution centers, such as Dubai International Financial Center, London Court of International Arbitration, Hong Kong International Arbitration Center, Astana International Financial Center, its Integrational Arbitration Center, are the only ones in Central Asia. Among the main, next slide, please. Among the main challenges, I would single out the need for further harmonization of the existing law on arbitration with the best international practices. At the same time, we need to build safeguards against private entities that establish affiliated arbitration institutions. In addition, we need to increase the level of confidence in arbitration as a way to resolve disputes in Kazakhstan. Speaking about the last challenge, I would like to notice that for a long time, litigation has been the only way to resolve the disputes. So due to the novelty of arbitration, we are working to increase its presence. Thus, currently, the Senate of the Parliament of the Republic of Kazakhstan has shown great interest in development of ADR, and in particular, arbitration in Kazakhstan. The amendments are being developed that are aimed to integrate the ADR with traditional litigation, ensuring courts practically encourage mediation and arbitration before trial. Next, please. To conclude, Kazakhstan has made significant progress in developing a pro-arbitration and ADR-friendly legal framework, aligning with UNCITRAL and the New York Convention cutting-edge practices. At the same time, challenges remain. Therefore, I would to thank all participants for their insightful recommendations that will be practically helpful, given the parliaments and other state bodies' interest in developing ADR in Kazakhstan. Thanks so much.
Thank you for your comprehensive overview of ADR development, legal frameworks, and ongoing reforms in Kazakhstan. So now we will open the floor for the Q&A. So yeah, please go ahead.
Thank you so much for your the comments. My question goes to the Kazakhstan because you are unique male speaker among all female panelists. Okay, according to my information, Kazakhstan they ratified the Singapore Convention is quite a unique situation. If my information is correct, would you share your some challenge? How did you overcome the challenge? Because some country already they signed the Singapore Convention, still they are not ratified. They did not ratify it. So in your case, you signed the Singapore Convention 2019, and then in 3 years you ratified that Singapore Convention. Please share us how did you overcome, how you were so fast to ratify the Singapore Convention.
Sorry, I would like to answer in written form. Your question so complicated for me. Sorry.
My question is that you ratified the Singapore Convention, correct? Yeah, but it takes only 3 years after signing. But some country, they signed the Singapore Convention, more than 60 countries, but still there are around 10 countries only ratified the Singapore Convention. Is there any secret, the reason why your country was so fast to ratify the Singapore Convention?
I guess there is no secret. 3 times is a long time. So I need to have some data about implementation this code. So could you give me some time?
So Rajesh, you have a question? Yeah.
I also had a question for our speaker from Kazakhstan. In your PowerPoint, at one place I read it was said that safeguard.
Mic, please.
Is it on? Yeah. In your PowerPoint, at one place it was written safeguard against captive arbitration. So I could not understand what is this captive arbitration.
Well, we have some issue, so-called pocket arbitration. So pocket arbitration, as you may be aware, it's arbitration established around some huge corporates. So we need consider how to regulate this kind of arbitrations. Thank you.
Please, Nadia. Yeah.
Not sure if this is on. I've just got a general question, not just for the gentleman, but for anybody. I'm interested, and I think this was covered to some extent, but I'm specifically interested in the type of incentives or requirements that your jurisdictions have that encourage people to go to commercial or civil mediation, or mediation in general, right? So whether, it could be a soft incentive or it could be quite a strong incentive, right? It might be, something more like promotion, or it could be a semi-requirement.
Does any country have that kind of incentives or could answer to her question?
I've got another question. Yeah. All right. Okay. So I've got a second question, which is, so my understanding is that worldwide, many civil law jurisdictions that have mediation also have a situation where judges in certain courts also mediate. A few common law jurisdictions have this, but not many. So I'm curious because I think we're largely civil law jurisdictions or mixed here. To what extent you have any courts where judges mediate, and if you do, if you think that has an impact on the development of private mediation.
So could you?
Hello. No, in the Philippines, our judges do not mediate. There's mediators for the court annex mediation to facilitate the mediation process, but not the judge.
Hi. So for Malaysia, we do have judges mediating, but not the judge that is hearing the case. So, but like I said earlier, it's mostly to domestic cases. I have not seen an international dispute as yet, but that would also depends on how do you define an international dispute, whether it's just parties or if it's an international contract itself, or depending what area it is. So that's the situation in Malaysia. Maybe I could try to answer your first question on the incentive. There is no particular incentive in place in Malaysia, but from what I see is that there is always the push in courts for certain matters, industrial matters, family matters, or even running down cases, to do mediation first. Not forcefully in the way that you would think, but it is encouraged very highly to go through that. I would also say that in Malaysia that we are negotiating a lot of FTAs, and as part of the clauses in the FTAs, we do have mediation in place, and it has either simultaneous timelines or before the arbitration or before court cases to be placed. I hope that answers that.
Okay. Thank you for the time. It's a privilege for me to be here. I'll try to answer your question about mediation costs. In Indonesia, the use of mediators, judges, and court official is not charged as a service fee. But the cost of non-judge mediator services is borne jointly or severally based on the agreement of the parties. I think like that. Thank you.
Can I just make a comment to that or not?
Yeah, and Nadia and then Hassan, yeah.
Oh, no, I was going to say
these two are the last questions.
My question around judges comes from a couple of experiences, but one it was in Germany where at one stage, this is going back more than a decade, the private mediation community felt so strongly that because judges were effectively offering mediation for free or for very little, it was confusing users and taking away their business. And they were going to bring a sort of a monopoly claim against the courts, but they ended up not doing it. I think they settled. But I was just curious as to if that had become an issue. So.
Please.
I've got two questions to Indonesian judges. Sorry. To your experience for commercial mediation, you think compulsory is good way or voluntary one? Secondly, Indonesian access to the Singapore Convention in 2019, and you ratified in 2021. What implications were there to your public or judicial institutions? Thank you.
voluntary mediation in Indonesia conduct after mandatory mediation fails can be conducted during the case examination until before the verdict in rendered. And voluntary mediation can apply at the legal remedy stage, appeal, cassation, and review levels. That's all. Thank you.
So thank you all your participations. And while each country has a unique approach to ADR, it is clear that we all recognize the necessity of developing strong ADR mechanism. And this session's presentation, I think we found that many Asian countries have a well-established mediation framework for domestic disputes with significant utilization. I think this is related to somehow the cultural familiarity with mediation in the region. However, as the international trade and cross-border investments grow, so the number of disputes between countries. So I hope tomorrow's discussions will focus on how each country can prepare for the national dispute resolutions. And so with that, I'd like to conclude this session, and a special thanks to all our speakers and presenters for their valuable contributions. Thank you, all of you. Thank you.